So my mining operation has been stopped. I have filed an IA. Matter will be listed for orders. I have also obtained the consent of the petitioner. And there are other three content matters. Well, these three content matters have been disposed of by my Honorable Mr. Justice A.K. Mahapatra. Well, I am for the opposite party. I have filed the IAs in three different content petitions for equal of those orders in view of my Lord's judgment that in the SLP is pending, content petition could not have. I made a mention for Honorable Justice Mahapatra on 21st. Court mention memo was allowed. Accordingly, the records along with the court mention memo brought to the listing section. Well, in the evening, I saw that it has not been listed. Then on the next, on 23rd morning, I inquired with the registry, and registry said no, the deputy registrar said no, it will not be listed because as per the orders of the Honorable Judge. These are the three matters.
Application. Item number 48 today's list, my lord. The matter is relating to applicability of CCA.
Which item?
Item number 48.
Out of list over.
The matter relating to applicability of CCA rules instead of police manual. Right?
Out of list, any out of list, just a minute.
Can you
Out of, yes, just a minute, just
Out of list.
yes.
Application under 482 for quashing, my lord. The petitions facing.
Why are you making mention here?
No, the difficulty is, my lord, the connected matter on which the stay has been passed and interim order has been passed, and we are relying on that. That belongs to the assignment of justice, was passed by Honorable Justice R.K. Patnaik. So therefore, the regular bench now, Justice Mahapatra said that no, you please place before Chief Justice, assigning any one bench so that both the matters can be tagged and heard together. His order also I am annexed.
You make, give a slip to the deputy registrar judicial. He'll bring that.
Man, this order is also there and annexed.
Two fresh content matters, 2024.
Fresh contempt matters, we are taking up 2012, 2013 contempt matters. Please wait for some time. Please wait.
Can it be in first week of September, my lords?
Please wait for some time.
My lord. Another one is writ appeal. The Honorable Single Judge's order regarding a service matter.
Why, when did you file your writ appeal?
This isn't filed long back, 1 month back.
Month back, we are taking up, let us see. Let us see.
My lord, I may be pardoned. I am not in fever today. So the nursing matters 13, 14, 15, 58 and 59 may be taken up day after tomorrow at 2 p.m. This can dispose of.
You just inform them.
Yes.
Last date is minor 31st of this month. Your lordship fixes last date for in other.
Tomorrow we can take up.
Tomorrow first date, your lord, 59 items.
Tomorrow we can take up.
Tomorrow at 2 p.m.
Tomorrow we will take up. It will remain there, but it will take up tomorrow.
My lord, last date is 31st. Your lordship fixes another case, covered matter.
Mr. Lenka, tomorrow.
My lord, may I pray at 2 p.m. lordship?
When we say we will take up, we will take
My
up.
lord.
Pardon your lordship.
Please give us slips.
This matter was listed on 20th August 2024. Your lordship specifically adjourned to 27th. But in the inadvertently, the typographical error, my lord, that has been posted to 27 and 9 to 30.
All right.
Tomorrow, your lordship.
All right, Judge.
Listing of the orders.
Give your slips also.
May I make a mention, my lord? It's a matter related to 10.
Item 53. I have informed Mr. Dayanand Mahapatra. I am for the petitioner. We are talking about resolving the matter. If it may come 1 week after, so that it will be resolved and I can withdraw the letter.
What resolution?
My lord.
Resolution regarding what?
My lord, admission of a student.
All right.
I am for the petition. Item 53.
My lord, item 48, my lord. The matter is.
Mr. Swarup, you are supposed to file the reply or a rejoinder.
Rejoinder.
So there is no urgency. No urgency in the matter.
My lord, item number 48 of today's list. The matter is relating to applicability of the CCA rules instead of police manual. Kindly fix a date for next 2 weeks.
It is not likely to be taken up today. And today it cannot be taken up. Though it's- It can be taken up for today.
Item number 3, as first place.
Lordships, may I be permitted to sequentially take your lordships to the series of events which would be very important. Your lordships, the first thing that I want to show is annexure 2, page 15.
So what relief you are seeking? What
Lordships,
relief you are seeking?
your lordships, in the background of the facts which have happened, especially when your lordships look at annexure 2. Annexure 2 was floated, it was issued with this intention that you make the inspection and it's not that the inspection should lead to an automatically that we will be out of not offering these studies, because your lordships, it's not only concerning of people who are today to be admitted, but also people who are still studying. So once you basically don't allow us, it has an impact on the entire structure. So annexure 2 was completely issued by the state authorities that you go and inspect for limited purpose, that whether they are eligible, their candidates will be eligible for getting the scholarships which are meant for SC/ST candidates. They did so. That is somewhere in November 2023. May I just place that small paragraph, your lordships? Small paragraph from that annexure. I'll just place it. Further, as per the decision taken in the meeting, a checklist is also attached herewith in continuation of the department letter dated 13/11/2023. It is once again requested to take necessary steps for completing the physical verification of all private and grant-in-aid institutions under your administrative control within 15 days. 15 days was a timeline. And certified for their continuation under OSSP, that is that scheduled caste, scheduled tribe benefits to this department. The certification given by the concerned department would be valid for 3 years unless any deviation brought to the notice of the department. So the whole process was a process of certifying. So you have a deficiency. We are an ongoing institution. We do have a deficiency. You let us know, we'll clarify it or cure it. Now, your lordships, following with this came annexure 3, which was sent very localized in the month of December, page 17.
Yes.
Now, what lordships, they completely keep quiet. This total silence. What they do is just simply delete certain institution from the name of the concerned website. So decision is taken first. Completely, you do not say what happens to these verifications. And therefore, the society writes a letter at annexure 4 series, page 18. You know, may I just, subject is page 18. Request from the State Private ITI Association to take necessary steps for display of the names of the private ITI in the state scholarship portal so that the trainees concerned of the private ITIs can apply for scholarship in state scholarship portal. Now, this would be also for students who are there in previous batch, because this is and your lordships will see para 7 of that. In this connection, a lot of representation and threatening letters from ST and SC students, as well as from the guardians, are being received by the association, stating that for the occurrence of law and order situation and revolution in the coming days. In this scenario, we are on behalf of the state ITI, and I request you to consider the grievance, take necessary steps to showing the names. Your lordships, nothing, they don't let us know anything. Followed by that, through an email at page 19, we send a representation. Then your lordships, at page 22, that entire timetable comes up. Something was conceived to be completed by the month of December. You don't communicate, you sit over the matter even after our letters. Entire timetable comes up. We are obviously trying to persuade them. Then your lordships, annexure 7 comes, which is their annexure D/3 in the count. Annexure 7, page 29. At annexure D/3, they have annexed exact wordings, 49 show. In inviting, may I just read
Yes.
this? In inviting reference to subject matter, I am to say that the physical verification of all private ITI conducted by the officers of government ITIs and government ITIs of the state in accordance with the letter dated 14/12/2023 of Director Technical Education, Orissa, Cuttack. The infrastructure and other facilities in your ITI was found deficient as per the inspecting reports. Reports not annexed here. Now, keeping in view the interest of the trainees and admission of ITI is being stopped for current academic year 24-25. Again, the entire admission stopped. So next step of decision taken, but we are not notified. We are not given the chance to cure it. In case you have any objection, you are requested to inform with reasons as to why the admission be allowed. They put the reasons on us without letting us know that where is that deficiency. You should reply and understand before 9/7/2024. Now,
So where was the permission granted for admission?
that's there, Your Lordship.
Where is that?
I mean, we have been taking admission here.
It is different. Where is that?
Lordships. No, there is no denial for us to come.
Maybe. We want to see the wordings of that. That is
Yes, I might
most
be
fundamental.
a copy of that.
Because sometimes it is given temporarily so that you subject to some conditions. If you don't fulfill that, they may not renew.
The
DGT guidelines, Your Lordship.
You know, that's very simplistic statement saying DGT guidelines.
No, please.
You're probably forgetting that.
Don't.
Yes. The issuance of that certificate is by the state authorities. I absolutely appreciate Your Lordship's doubt that if that format is seen, better light would come. I think all the private ITAs are also there, that they must be annexing their certificates also. I think I can point that out from there. Your Lordship, having said this, this is the format which comes to us. In the month of July, we have December 2023, everything is over. After much persuasion, this comes to us.
So, but whether are members of this association?
Yes, Your Lordship.
Then why have you come?
You know, so we have come in behalf with the common understanding.
They have already come. Why should you?
They came much later than us.
No.
You know, so one very profound thing happens at this stage, and which comes out from their counter. This annexure they have sent to 49 institutions. They have not explained, and they also don't dispute this fact that no reasons were given to any one of them. Very strangely, 29 of them or 28 of them somehow are seen to be compliant now. There is no explanation. Reasons were not given to everybody. The society is writing also in behalf of everybody. We are persuading you. What happens with that? What happens with that 28 people? What did they write in their show cause reply? Nothing brought on record. Your Lordships, with all respect, transparency is a very important thing, and reasons is part of the transparency. This is what happens. You are not giving the reasons. 29 people somehow suddenly seem compliant overnight, and we are not. And then Your Lordships, followed after so many things, and they
whether you have taken this plea in your writ petition.
So we just came from the counter. We did not know about it.
Then have you filed any rejoinder?
No,
Your Lordship, 29 has been summoned.
I've not filed a rejoinder to that extent, given this situation. But Your Lordship, look at Annexure 9 reflects that. Annexure 9 view reflects that.
See, you will have to take a plea, specific plea. Otherwise, we cannot decide on the points which are not there.
Annexure 9. Annexure 9, Your Lordships. We'll just look at Annexure. Bereft of that also, Your Lordship, the fact remains that they have not been, they have been arbitrary. Annexure 9, Your Lordships, we write to them. The inspection of the post-metric scholarship of different institutions were carried on December 2023 and January 2024. There are few institutions who have received letter regarding admission from DTET or to submit a reply and so on so. But without waiting the compliance letters from concerned institution, you have deleted the names of aforesaid ITs.
There is difference. They are not required to answer the allegations made in your representation. They are required to deal with which you have made in your writ petition.
Lordships, I'm not denying that. What I'm trying to say is, here again we are pleading. Please tell us the reason so that we comply with it.
You are pleading in your representation.
No. What we're saying is, Your Lordships, what we bring it to the court is facts which have happened. What we are trying to impress upon the court is that this is something that we have been continuously going to say, tell us the reason, tell us the reasons.
You may be correct in your submission. See, now they have taken some stand.
They have not denied, they have not communicated the reason. They have not denied that stand.
They communicated the reason. This is one aspect.
So that
You are saying that some of the institutions have been allowed to admit students.
yes, Your Lordship.
You have not been allowed.
Lordships.
There is no reason why they have been allowed and you have not been allowed.
We do-
Both things.
That's
There is
the
no
on the
reason-
counter. They admit that in their counter.
They admit?
They admit that portion in their counter.
No, but had you raised such plea?
Your Lordship.
Where is the question of admission of this stand?
Your Lordships will kindly appreciate. It's not something that you're not doing a witch
No,
hunting
we
at
are
all.
not saying that. See, after all, we have to decide the matter.
Your Lordships.
And we have to decide the matter on
Your
the
Lordship.
basis of affidavits, pleading issues.
Yes, Your Lordships. But I think we do make out a case that if you are a body, state as a body, if you are regulatory in nature, and you are to see that we meet certain standards, and you found us deficient, you should have communicated to us.
That is one aspect.
So
There you may be right.
Your Lordships will kindly see, even after this letter, where we clearly say that till date we do not know the reasons, please tell us. This letter was strictly only, please tell us the reasons. Because time was running. And Your Lordships, what is that they do? They again hold another inspection, mobile inspection.
All right.
Okay.
We have another query before you proceed.
Lordships.
So whether 19 institutions which have been allowed to admit students, they are members of your association or
Lordships,
not?
they're members. We are not disputing that they're members. If they have been found deficient for some reason, they are members. We are
No,
not-
those
I'm
who
not
have been
going
found,
against them.
in such college, in such institutions where there has been no deficiency found, those which have been allowed.
Lordships. We've not grievance with that. That's why we're not taking the argument to that far. What we're trying to say is, we're not taking the argument that far.
No favoritism.
We're
favoritism.
not taking the argument that far, but definitely harping on this fact that if transparency was there, we all would have got a fair chance. Now, I'm not taking the argument that far. After that, you had a mobile inspection. I do not know how they inspect through a mobile phone and how transparent is that. Even that report you did not supply us. Your Lordships will kindly see Annexure 10, page 32. They go for a second inspection. Even reasons in that you also don't provide us. And then finally what you do, you delete our names completely from admission and you issue an Annexure 12 that you are found deficient, we are just deleting you. The entire sequence of events sometimes makes me feel probably that report was not there. And to in fact, look at that report is not there. Your Lordships will see the report that they have filed. Signature, not a single signature of any authority.
We have doubt whether you can maintain this writ petition or not, given the facts and circumstances on behalf of the association.
Lordships, I have judgments to that extent, Your Lordships.
If the decision relates to particular institution or the decision is institution-wise, you can, as an association, question policy, which applies to everyone. But if some of the institution decision has been taken, this association.
Your Lordships, I am not going to that extent that who have been now allowed to. I'm not pressing that argument.
No question of allowing. See,
Lordships.
if there is a principle adopted by the state government, which according to you is unfair and just, which you are challenging as a body, you can challenge. That can be entertained. But the moment you are saying that this institution has been disallowed, and therefore that particular decision is incorrect, as association you cannot question that.
Your Lordships, we have been, Your Lordships, single institutions were not able to influence them. We're not. Because, Your Lordships, when we issued Annexure D by 3 also, thereafter we have been telling them that just simply supply us the reason so we can just cure it. Your Lordships will kindly just see.
That's not the question. That plea can be taken only by a particular institution, not by association.
Your Lordships will see all the letters which the institution has written for those small amount of we are standing, the society is standing by the fact that around 29 institutions.
We will consider all the submissions which you have make that on the behalf of the institutes which have come. We can consider, not on behalf of the, how many restrictions are there?
Lordships will let's just look at Annexure 5/3, F/3. Not a single signature of any authority on that report.
No, maybe.
They're producing it before your
That is not the
Lordships.
question.
Your Lordships, today also they're producing before your Lordships is this.
That is not the question. The question is whether your association can question the maintain the.
Your Lordships, that
we will decide.
What is your membership? How many members?
400 sons. 400 sons.
Because as per the counter, there are 418 ITIs.
Yes, 400.
And 47 had been disallowed.
49, which reflects from.
Thereafter,
yes.
26 are remaining. Others they have allowed.
29 remain thereafter.
26 remain as per the counter.
Your Lordships will, it is still authority. Your Lordships may kindly, where is the paragraph? 53.
Now, your Lordship, after the second inspection, 3 were allowed.
Will come.
Your Lordships may kindly just. Your Lordships, here one of the questions which was because under the Act, the person interested was defined. So your Lordships, finally at para 53, the court did hold that the association therefore could have filed an application representing its members, your Lordships, and need not necessarily be all the members, your Lordships. Because here no members are really at loggerheads with the other member. All that we are out of judgment.
Now come to paragraph 53.
53,
You are referring to paragraph 53.
Yes, 53, your Lordships.
Yes.
They could have filed a writ application, your Lordship. That's what they said. That the
Just see.
statute may have prevented you to
See,
maintain
it
a
is
particular
not-
reference
See,
there.
See, you can maintain a writ application. But
Lordship.
the fact is whether in the facts and circumstances you could maintain a writ
Your
petition or
Lordship,
not.
I do not see any reason not to be able to. And along with that, we do have also the
All right.
institutions.
All
with
right.
us.
So tell us by
The writ-
by which order the one institute has been, one ITI has been disallowed.
It's an example we had given that. Same letter, sir.
So
Same
same letter-
letters, your Lordship.
Same letter will have to be challenged by, see, there may be ITIs who may not be fulfilling the criteria.
Your Lordship, that's
They may not be willing to
why, your Lordship, I was also trying to show us this. Major allegations which they have made are on the face of it rectifiable.
and
Like
therefore
lease deed was not given.
Therefore, madam, had this been a question of policy, the matter would have been different. Here, individual decision been taken in respect of
Your Lordship,
individual
decision, your Lordship, that's exactly what I'm trying to say is that, is this a decision under law? When you don't provide a reason.
may not be.
May
Not be under law, but who are you to question is the question.
Your Lordships will kindly. This society in its power has been representing and they have been
Where is
acting upon
your
it.
association? Where is your memorandum of association?
We'll produce, your Lordships, your Lordships, even in absence, your Lordships, now I would also say, even in absence of that, now we have the ITI institutions all have filed a writ application along with
we
us.
will entertain.
Lordships, along with us.
That we will entertain.
And-
The individual applications we are there
And
to entertain.
Lordships, this remains their undisputed stand of the state in their counter. That they haven't
Maybe
disclosed
the
reasons.
question is whether we should dismiss the writ application at the very threshold.
Your Lordships will kindly see, as far as these two judgments are concerned, they do say that these kind of association can maintain a writ application. There is no doubt about it. I leave it rest to your Lordships. We have made out a case, undisputed case before this court, both from the pleadings and in specifically admission from the side of the state, that they haven't supplied any reasons, even though they are sitting over the matter from December 2023. There is no doubt about it. And to that extent, Your Lordships, I'll just cite one judgment.
On association.
Association, I've cited.
That is the only thing.
Yes.
This is the only judgment.
And there's another one, Your Lordships.
Yes, please.
Where Your Lordships may look at para 8 and 9. Para 8 and 9, Your Lordships, we look at this judgment, which will be as regards to association maintaining a writ application.
Yeah.
And Your Lordships, this judgment which I am insisting upon is Kranti Associates is para 47.
No, Kranti, why are you referring to Kranti?
Because
Kranti will come later.
Your Lordships, that's what I said. That as far as association maintaining this writ application.
Kranti is not association.
No, Your Lordships. What I'm trying to say is this. As far as the question of the bench that the association's ability to maintain the writ application, I've given two judgments.
Where is that? Let us see.
Your Lordships, yes, one was that para 53, and the next one in the other judgment, where similar question came up. The question on para 8, the first question, whether the union has the locus standi to maintain the writ application as well as the present proceedings on behalf of the workmen. Specifically because workmen itself are single person interested on the respective statutes. And the answer, Your Lordships will see.
This is entirely different. See the reasoning, the logic given in paragraph 9.
Lordships. I understand. Common.
That is entirely different.
Common. But Your Lordship, what I mean to say.
Because instead of going to those aspects, we can consider individual cases, we can decide, not through association. These are quite distinguishable.
Then Your Lordships, as such, the individual associations are there. Let the same argument be also, seen in that light. Because I think, because at least that much I can plead on the whole issue. But Your Lordships may also look at Kranti Associates to that.
Kranti Associates is Kranti, there is no doubt.
Yes, Your Lordships. Because primarily, there is a total admission on their part of being unreasonable.
See, even if we are satisfied what you are submitting based on the decision in Kranti Associates, there are so many decisions. The question is whether those points can be taken into account in your association. Therefore, just tell us which other writ petition is there.
They're all there. They're all there on record. They're all there on record today. They're all listed along the same matter. They're all listed the same matter. My only thing will be
so
there.
Let us come to one of the writ petitions.
Madam. I am for the institution, madam.
Which case?
Vivekananda Industrial WPC number 19924 at 2024.
So whether in your case counter affidavit has been filed?
No,
Your Lordship,
because
this have been issued.
no notices have been issued.
Your Lordship, I am supporting for the association and individually institution I have filed, madam. Open, my lord. All the institutions are old institutions. See, till 20 years, 25 years, and not less than 20 years, all ITSs, my lord. Your Lordship got Annexure 1, running page 12, my lord. That is, Your Lordship got it, my lord.
Yes.
That is the affiliation letter, Vivekananda ITC and all. That is letter issued in 28/8/2009.
Yes.
Till 2009, this institution maintained all the criteria fulfilled by the DGT guideline as per the norms, my lord. What happened, my lord? What happened, my lord? All the institutions affiliated by the guideline which is fixed by the DGT as per the norms, that is the affiliation guideline, my lord. and all institutions continuing since academic admission, all the things since regularly, my lord. What happened, my lord? The opposite party issue first admission notice on dated 28/2024, my lord. The first,
28/3, just a minute, 28/3/2024.
my lord, Annexure 2 series, my lord. Your lordship kindly peruse running page 13. I have already given the English translation copy also, my lord. Your lordship kindly peruse running page 13.
Yes.
The IT belongs to the students being informed the education years 24-25, the admission in the government and non-governmental industrial institutions are going through some potential for the admission is being accepted from 1/4/2024, my lord. That is a first notice, my lord. What happened, my lord? All the
Now,
academics.
what is this ITI Tamil belonging?
Belonging in the private, non-governmental and non-governmental institution, madam.
No, ITI Tamil belonging in.
Industrial Training Center, madam. ITI and ITC.
ITI Tamil belonging interested student.
Then that is the IT Talim.
Talim.
Not Talim.
ITI Talim.
Yes, translation. Talim. Yes. Yes, madam. Talim. निमित्त इच्छुक छात्र छात्री मानक सूचना दिया जाउचे that is English. Yes, translation problem.
So have you applied a AI?
Yes, madam. I have written Odia.
Have you applied
I
AI?
madam. ITI.
Have you applied AI for translation?
Yes, sir.
Yes.
Madam Lordship can. ITI तालीम निमित्त इच्छुक छात्र छात्री मानक सूचाई दिया जाउछि जे 2024-2025 शिक्षा वर्ष राज्य सरकार मानकर साम पोर्टल जरिया रे केंद्रीय ऑनलाइन पद्धति रे नाम लेखा जिवो एथिपाई ऑनलाइन माध्यम रे आवेदन 1/4/2024 रिख ठारू ग्रहण करा जिवो नाम लेखा प्रणाली आवेदनकारी 1/8/2024 सुधा 14 वर्ष होइथिबे किंतु सर्वाधिक बयस सीमा किछि नाही विभिन्न इंजीनियरिंग एवं अण इंजीनियरिंग ट्रेड पाई निम्नलिखित शिक्षा
All right. This was the notice. Then
first notice, my lord. On the date month of 3rd, my lord, in March or 28, 2004. Thereafter, my lord, another notification also given by the opposite party on 35/2024, my lord. So that series, my lord. Thereafter, another extension notice, my lord, 1/8/2024, my lord. In between, my lord, all of a sudden, the inspection come by the opposite party and allow the issue the letter against the opposite petitioners, my lord, institution, my lord, that on dated Annexure 4, 3/7/2004, my lord, disallowing of the admission, Annexure 4, my lord, disallowing the admission during year of 24-25 on the basis of inspection report. It continuing for the post metric scholarship regarding, sir, inviting reference subject. I am to say that the physical verification of all private ITI.
which page you are reading, Mr.
Running page 16, my lord, Annexure 4.
16.
Running first.
Yes.
Conduct all the notification continuing since month of 3, my lord. Thereafter, month of 7, that letter issued by the opposite party. The Director Technical Education, the opposite party number 2, on dated 3/7/2024, my lord. Disallowing the admission during the 24-25 academic session inspection report, my lord. In inviting reference to the subject cited above, I am to say the physical verification for ITI was conducted by the officials of the government ITI, government ITC of the state, according to the letter on dated so-and-so, 4/2/2020, Director Technical Education Training. The infrastructure and other facilities in the state and your ITI has been found deficient as per the inspection report. Now keeping the view of the interest of the trainees, admission in the year of ITI is being stopped for the current academic session 2024. But in this letter, my lord, they are not providing the deficiency. The old institution, my lord, intentionally they have done in mid of the session of the academic session, my lord. But all the actions by the previous inspection, which is done in 2023, my lord,
Why
last,
intentional? Why are you saying-
why telling my intentional, my lord? Inspection done on dated on December last and January first week, my lord. They have listened, sitting in silence. All of a sudden, they have issue on the letter on
Why
dated.
are you saying intention? We want to know what was the-
Because they are not providing the deficiency letter, my lord.
That may be legal, Mr. Counsel, but why are you imputing malice? On what ground? When you say intention, that is
Nothing else, my lord. Simple inspection.
That
They
is
are not following the norms and guide of the DGT, my lord.
an act may be illegal and an act may be tainted with malafide. There is difference between two.
Yes,
So
ma'am.
don't use this word intention.
Yes,
If
ma'am.
there was some intention, you can demonstrate that.
Madam, sorry,
You can
sorry
deal
for
with
that.
that also.
Madam, what happened, my lord? The admission notice
All
is,
right. So and after
that is old institution, my lord.
you have simple submission
Yes, ma'am.
that the admission notices were issued initially in March 2024. The
Obliged.
date was extended
Yes, ma'am.
up to 1/8/2024 when the last notice was issued. And in the meanwhile, you have been disallowed to admit students
Yes, ma'am.
without any valid reason.
Yes, ma'am.
Is this not your submission?
Yes, ma'am. Obliged.
Beyond this,
Yes, madam.
there is no reason.
Yes, ma'am. But what happened on 30-40% students already taken admission in all the institution, my lord.
All right. So in the meanwhile,
What the future of the students, my lord? You're
Yeah.
sympathetic, you will explain all the
understand
things.
this fact that before when were you disallowed?
In 3/7/2000, twice, my lord. On dated 3/7/2024, my lord, and another letter,
2024.
another 5/8.
Just a minute. So before 3/7/2024,
Yeah.
you had already admitted students.
Yes, my lord.
This is your case.
Yes, my lord.
Where have you-
Old institution, my lord. So that,
where have you said
yes,
for 2024-25 you had admitted students
yes.
before 3/7/2024? Where is your
In a read petition, my lord, your lordship. Your lordship, in paragraph 12, my lord, submitted director letters on dated 18/7 directed inspection the infrastructure ITC admission students sessions 2024-25 without conducting the inquiry for the session of 24-25, the action of the
yes, we have
opposite
seen
party.
paragraph 12.
Allowing the student the petition ITC in the mid of the session is
How many
impossible,
petitions are
and
here?
particularly around
We have
the-
seen this. We have seen. Please take.
Obliged.
So there are two aspects.
Yes, Your
One, that they appear to be right in their submission that your communication does not contain any reason
Yes.
why they were being and what were the kinds of deficiencies. Absolutely nothing. And secondly, the admission notices were issued in March 2024. You took this decision in 3/7/2024. It is their specific stand that in the meanwhile they had admitted some of these students.
Yes, Your Lordship. Lordship, I filed also an additional affidavit on Friday, stating on record that we have individual reports of all the ITIs signed and
But you
reports.
did not
But we have annexed the downloaded copy because it would have become bulky, Your Lordship, with the
No, but
individual
you did
reports.
not communicate those.
No, Your Lordship. What has happened is that, Your Lordship, the background of this case is that the ST and a department of the state with the implementation of a post-metric scholarship that is a centrally sponsored scheme of the Ministry of Tribal Affairs and Social Welfare, Your Lordship. They revised the guidelines. They said that now the institutions have to be verified, physical verification of the institution has been done. And on the Prerna portal, OSSP, for the Odisha State Post-Matric Scholarship Portal, there the institutions have to be now registered. Earlier, Your Lordship, it used to be the SC and ST students used to personally register themselves on that portal. But the ministry, central ministry, they said that no, it has to be the institution. So
When?
that was in 13/11/23, the letter, Annexure A/3, Your Lordship. Then, Your Lordship, the Chief Secretary, he called for a meeting, and with the CAG of India, they were all present in that meeting. they took a decision that as to what has happened of the follow-up of the scholarships of the previous years. There, the CAG and the chief secretary and all, they decided that it is better that personal students don't register here, but the institutions register. They will be physically verified and institutions will be registered. That is a letter B/3, Your Lordship.
What is that? What is the date?
That is, Lordship, date is 24th November 2023. And they directed the opposite party number 3, the director DTET, to inspect, do the physical verification. Director Technical Education and Training, Your Lordship.
Yeah.
He was asked to do the physical verification. So he instructed all the government polytechnics, ITIs, and all of the areas concerned to inspect, Your Lordship. Now, this physical inspection, the first physical inspection, Your Lordship, it was done in a phase-wise manner. And the reports were submitted to the SC and ST department in a phase-wise manner. Where the institutions which were found to be deficient, they were deleted from the Prerna and the OSSCP portals, Your Lordship. They were not allowed. So these inspections were done in the presence of the institutes, Your Lordship.
No, where is that?
That is, Your Lordship, annexure D/3, Your Lordship. Consolidated report is C/3, Your Lordship, or the physical verification. It's a consolidated report, Your Lordship. We have filed here for the courts, Your Lordship, ensure the courts, but we have individual reports also, Your Lordship, signed, and in a phase-wise manner, this was concluded on 26/4/2023, Your Lordship. And in a phase-wise manner also.
Just aware.
Yes.
You are referring to B/3?
C/3, Your Lordship.
C/3. Yes.
Yes. Then, Your Lordships, the department also deleted these institutions or did not allow them to register themselves because of the deficiencies. So in their presence, the first verification was done. They were also not allowed to register themselves in the portal, Your Lordship, because of those deficiencies. These all took place in December, January, February, March. The last report was submitted, consolidated report was submitted on 26th, because it's pertaining to 418 private ITA institutions and grant in aid institutions, Your Lordship.
By the time they had already conducted admissions.
Your Lordship, that I have to verify. Yes. Then, Your Lordship, the general elections followed, Your Lordship.
No, we are not concerned with that. See, whether
these 47 institutions were barred by the first physical inspection.
When?
That took place on 4/12/23 to 26/4/24. In a phase-wise manner, Your Lordship.
Where is that?
No.
The consolidated report, Your Lordship, I have taken that government in my counter also. And the consolidated report is C/3, Your Lordship. Your Lordship, para 6, Your Lordship. And they did not allow 47 number of these private ITIs to register themselves on that portal.
You are referring to what? Para 6 or
Para
what?
6, Your Lordship, the last of the counter affidavit, Your Lordship. Page 6 of the counter affidavit. Basing upon.
Where is the document?
Document is C/3, Your Lordship.
C/3 refers to 47.
Yes, Your Lordship. 47 institutes. These 47 institutes were found to be deficient, infrastructurally deficient, and therefore they were not allowed to register themselves on that OSSCP portal, Your Lordship. Basing on this, the 47 institutes were debarred, Your Lordship.
Where is that?
Your Lordship, the last remarks not recommended. The last remarks. Disallowed, Your Lordship. Those are the.
Not recommended. Where is that?
Your Lordship.
That is D/3, which is the nature of a show.
Yes. Your Lordship, that is the D/3. D/3. This D/3 is the, sorry, Your Lordship, 67 page. No, Your Lordship. They were disallowed on D by 3, 1, 7, 3 cents. Those are show cause notices. And the report E by 3 is the consolidated report, Your Lordship. E by 3. Not recommended. All those were given. Those reports were given. Then, Your Lordship, out of these 47 institutes were issued with a show cause.
OSSP?
OSSP, Orissa State, Orissa State.
Scholarship portal.
Yes, Your Lordship. Portal. Odisha State Post-Matric Scholarship.
Orissa State?
Post-Matric Scholarship, Your Lordship. Scholarship portal, Your Lordship.
Just a minute. Let us understand. So this was not only for this OSSP.
Yes, Your Lordship. Actually, it started, this inspection was for this OSSP, Your Lordship, for providing. There, the norms had changed, revised guidelines. Earlier, students used to personally register themselves on the portal. But after the changed guidelines of the center.
No, that is not the question. Now the question is whether these ITIs can give admission at all or not. Forget this scheme, OSSP.
Yes, Your Lordship. Now, Your Lordship, it was within the knowledge that they have been debarred to for registration on the OSSP portals.
When they had this knowledge?
From December to April, Your Lordship, in a phase-wise manner, the reports were submitted.
No, the reports were communicated to them. The decisions were taken.
That
the decisions were taken that they will be debarred and they have been debarred or
they have never challenged that. They have never challenged the debarment.
Where is that?
Your Lordship, that they were told physically to verify. They were told because it happened in their presence, Your Lordship.
Oral.
Your Lordship,
Orally.
that I have no knowledge as to whether the scholarship part, what they were communicated. But this was the first verification, out of which this 47 who were debarred from that to register
I have
themselves.
not been able to find out that.
Yes. No,
Where is the decision debarring 47 ITIs?
Lordship, I'll seek instruction from the SCST department and I can file an
See, you have already filed a counter affidavit
Yes.
in one of the cases.
Yes.
We will dismiss that on the ground that the association cannot pursue. But we will take up other matters.
Yes, Your Lordship.
So you should file your affidavit by Monday. In one of the cases.
May I tell one thing, madam? Admission cut-off date is 31st, madam.
31st.
August 31st, madam. What happened, madam? We are not disputed for the scholarship, madam. We are for the admission, madam. Cut-off date is 31st,
Lordship,
madam. Otherwise, all the students will be, future will be lost.
Your Lordship, since these institutions, what has happened is these institutions have
scholarship, madam.
deficiencies through the Hill,
Only delay, madam.
where some of the institutions didn't have students nor staff nor faculty at the time of admission. They are just like the namesake, Your Lordships. Most of the ITIs who have been debarred are namesake, Your Lordship.
See, it is not that the interest of the ITIs, private ITIs, is not there in our mind. It is not that we shall allow them to do whatever they want, contrary to law. Let us see what can be done.
Yes,
one of these private ITIs, of course, that matter is not listed. And I'm also appearing in that matter.
So if any decision is taken, that shall be
covered by this.
Rightly actually pointed at the crux of the matter is that you went from one scenario of just seeing how the scholarship will be disbursed, but you finally landed up taking two decisions. One is debarring us from that, debarring the institutions, and finally completely debarring us in the midst of this.
All right, let us see what
yes.
Lordship, then on 3rd, because of the ensuing elections, Your Lordship, all the officials were on duty, election duty. But on 3rd, the OP number 3, after finding out from the report the discrepancies that was there with these ITIs, Your Lordship, OP number 3 thought issue a show cause notice, Your Lordship. And they were told by 9th that you report with all your documents. Because all these investigation or was done in their presence, Your Lordship, verifications. Out of the 47, 29 came forward, Your Lordship, and after 29, 28 for the, and one was without the DGT informing the DGT, he had shifted his premises. Out of that 29, Your Lordship, once again, the DGT director, who's a representative of the central government, formed a team and they verified, Your Lordship, with all the documents and all. And out of which 3 were given the permission to admit students. They were found right. Rest were rejected, Your Lordship. But the other 18, they never came forward also, Your Lordship. From 3rd of July till 9th of July, they didn't even come forward. Whereas there was something wrong with the institution. There were some rules that they had not followed. It was within the knowledge from December to...
Those 19 ITIs have approached this court
Your
by
Lordship,
filing separate.
By separately. Madam is a 3 IT.
Those 19, just a minute. Those 19 have filed.
I have no knowledge.
How
Your
many
Lordship.
writ petitions are there?
I am 5. And Madam is 3. Madam is another. He is 4.
But he had come forward, I guess, for a second inspection. No. Yes.
My Lord, what happened, my Lord?
26.
We,
No, 26 plus 18.
may I please?
40, out of 47, 3 have been given permission.
You are saying that
44
out of 47, 19 did not
come.
respond.
18 did not
18
respond.
did not respond.
Yes, Your Lordship.
Our question is
13,
whether
13,
those
please.
institutes have filed writ petitions or not.
5,
Which are those 18?
14.
at least 14 of them.
14 already in your court, my Lord.
14 are there.
Yes. What happened, my Lord?
Yeah.
So why didn't you respond? The so-called notice was issued to them.
Yes,
Your
Your
Lordship,
Lordship.
same. D3, Your Lordship will find all 49
all
show
on
causes
third.
are same thing. Your Lordships, in fact, in law, show cause means you will cite the reason and ask for show cause. No reasons in that show cause.
Madam, you could have gone there and told them that this so-called notice does not have any reason, therefore I cannot answer. See, there is difference between not responding and responding something.
Your Lordships will, but Your Lordships, in law, that's not a show cause. That's
No,
a decision.
it may not be so cause.
Your Lordship, look at that's a decision. That's not a show cause.
No. See, if you are right, if we are not saying that you are incorrect, that so cause is not so cause. If you go and tell them that it is not a so cause, we are not required to reply to it. We can't reply.
Your
But
Lordship,
if you don't respond, then it has different connotation also
Yes,
that you
yes,
accept.
I think that connotation that it's a show cause is something just flowing from the mouth of my friend.
What is
That's
there?
not the
What is
wording
there?
of
What is there?
2000.
What is there in this so cause?
20. Your
Or
Lordship,
if it is
look
not
at-
so cause?
what is the language?
Yes.
The language subject matter. Disallowance of the admission.
Which one?
D by 3, Your Lordship, D by 3 similar for all the 49 institutions.
Yes.
Word by word. Disallowance of admissions during AY 2024-25 on basis of inspection report, continuation of post-metric and of OSSP regarding. Inviting reference to subject matter, I am to say that the physical verification of the private ITI was conducted by the officers of the government of so-and-so state in accordance with the letter dated so-and-so. The first letter, in fact, which I had cited. The infrastructure and other facilities of ITI found deficient as per the inspection report. Now, keeping in view the interest of the trainees, all admission to your ITI is being stopped for the current year of 2024-25. They said inspection basis on inspection. I just
See
stop
the
it.
last.
Yes, Your Lordship, last. In case you may have an objection. Your Lordship, when decision is taken, there's not a show cause in law.
No. In case you have objection, you did not have any objection.
Your Lordship, that's the reason why a common objection was filed. Through the society, it was filed. That's been communicated. Through the society, the objection has been filed and their specific stand was taken that please give us the reason. Some of the reasons are lack of lease deed. We could have provided the lease deed. Rectifiable defect, Your Lordship. Some of them was that the load in your power connection is low. Rectifiable defect. Rectifiable.
Just think of a situation that this letter is addressed to Narayana Institute of Industrial and Technology, and the association is approaching.
No.
Narayana Technology could have done this.
Your Lordship, in writ jurisdiction, that's the thing that Your Lordship, a substantial justice. It's not that they were not continuously informed about the lack of reasons.
See, your non-response communication dated 3/7/2024 indicates that you knew that there are deficiencies and you are not required.
No, my lord, no, my lord. In our part, my lord, in all ITI, we have already given this clarification report.
Therefore, there is difference between those ITIs which responded to this communication and those who did not.
Yes. I have already clarified, my lord. What happened, my lord?
Therefore, you file your affidavit because last date is 31st.
Yes, Your Lordship.
File the affidavit on today, on Thursday.
Thursday, I'll file.
Thursday would do it.
My lord, what happened, my lord? The last
last date can be extended by the court's order if required.
My lord. Otherwise, no.
Your Lordship, if
Otherwise, we are making it very clear that in no case we shall permit such ITIs to give admission who do not fulfill the criteria.
Oblige.
In no circumstance.
Yes, my lord. Oblige.
We will take care of
press inspection. Your Lordship directed.
We shall take care of violation of the point of violation of principles of natural justice that will have to be addressed.
My lord.
All right.
Yes, madam.
So that we shall keep in mind.
Yes, madam.
And
For this session, my lord, I am approaching for this session, my lord. That is a mid-up session.
All right.
In another session,
Allowed.
Yes, already taken.
Disallowed from 4th September.
No, we have already taken.
Disallowed.
We have already taken admission, my lord.
No, thereafter, Your Lordship, they had a second inspection.
They were allowed.
Yes.
That's a strange thing. Thereafter, they went for, Your Lordships, I think what has been submitted may not be correct according to averments. The averments in their counter don't really show that whoever submitted a representation, all of them have been allowed.
No, that is different. Some of them might not. Therefore,
only 3 have been.
Therefore, madam, these matters are to be addressed individually, in individual cases.
Yes, Your Lordship. I'm also there in 5 individual matters, so I can submit to that extent. Is Your Lordship will kindly see. So what really happens is.
So just a minute. Which is your individual case? Which is your individual?
They're not
just
there,
for an example.
They are not there in Your Lordship.
Not even a single.
Not a single. But Your Lordship.
My matter also.
But Your Lordship, look at the documents of a particular institutes I have submitted.
Oh no. See, the letter says, you have any objection, you respond. So whether you have taken this plea.
Your Lordship, may I just say what happens thereafter? After 3/7/2024, when they do realize that they had not communicated, they do go for a second inspection. That's it. No, let me complete. That second inspection happens for these 29 institutions that she's talking about. Then comes the final decision.
Madam, you are making general submissions. Just tell us whether
submission, Your Lordship. That letter is there on record. Your Lordship, that letter is there on record.
Which case?
Your Lordship, look at that letter.
Why association we will not see?
Your Lordship, that's
the association matter we will not see.
Your Lordship, if Your Lordship,
you represent which ITI?
It has not been listed. What is it ITI?
That's not listed, Your Lordship.
And you filed the documents of a particular ITI in this. So you file on behalf using those documents, file a separate application.
Yes, Your Lordship. What I mean to say is, they themselves have also filed that document that they did go for a second inspection.
Madam, that is irrelevant.
Your Lordship, that's the
question. The question is, did you respond to the letter by which you were asked to submit your objection?
Probably it loses the significance for the simple reason. Your Lordship, probably that loses the significance for simple reason because they went for a second inspection for all the 29 institutions. All the 29 institutions came up with the fresh reasons. They came up with the fresh reasons. That was also not communicated. That's what we are trying to say, Your Lordship.
Reasons have not been communicated, then you say fresh reasons.
Your Lordship, why we will say so? Yeah. Your Lordship, just look at the
file your affidavits. What are those cases? Those cases will have to be listed.
If I put in Your Lordship's indulgence, if the list can be given to me of the fresh cases, I will.
All the
Because your
cases
lordship
have
said,
to be
if you look
discussed.
at the final order, final impute
Yes,
order.
yes, I'll-
See,
specific
we will
deficiencies,
address those.
specific deficiencies also.
Which in fact, my friend also pointed out the final impugn order in his case also is after the second inspection.
Madam, in his case, he had filed his objection. Those institutes which did not file any objection, that those cases are different. Those cases will have to be separated. They did not have any objection. They did not have any objection, irrespective of any subsequent inspection.
It's okay, whoever is.
Make your- give your-
If your lordships are to confine the relief to people who are there before
We
your
don't
lordship.
know. These observations are tentative. These observations are not final. So
Lordships.
this is there is difference between. We will see.
My lord, tomorrow.
We have not heard your case yet. The case which we have heard, according to us, prima facie not maintainable, that association. So individual cases, give your slips, we will list those matters.
Your lordship, if they might give me a list of all the fresh cases that they filed, so I can
I say
speak instructions.
one thing, my lord.
Date will be extended.
Oblige.
I am for
Oblige, my lord.
similar matter. The same has not been listed. Kindly take along with this case, my lord.
So why didn't you make a mention at 10:30? All right, give all the list of all cases. List of all cases. Tomorrow we will fix a date.
Yes, ma'am. My lord, one thing I'll tell. We are agree for re-inspection, my lord. But so far, this session is concerned because all the IT got a permanent affiliation, not temporary affiliation. But already of session, already taken admission 30-40%, my lord. In this session, otherwise, your lordship directed anything for the inspection, guideline, all the things as per the guideline, whether that is building construction or deficiency of the electricity or tools equipment, or anything to be fulfilled. That is a world institution, my lord. So in this session is where
Let us
oblige. Tomorrow, my lord.
tomorrow.
Yes.
Tomorrow you give the list.
We'll give it right.
And please give your list. Yes, yes.
Tomorrow.
Item number 1.
Yes, so is for the state. He has filed a supplementary affidavit. Who is for the municipality?
The affidavit, my lord.
He has filed an affidavit.
My lord, there is written member infectious.
Infectious.
My lord.
Why?
My lord, the petitioner challenged the tender of 2022.
Yes.
Meantime, an interview order granted by this honorable in connected case, he is continuing since last 4 years. And the petitioner challenged for 2022.
Yes.
It is a fresh tender, my
For 1 year.
lord. Not 1 year, my lord. If let they say that they have cancelled this tender, my lord, then it becomes infructuous. If they have not cancelled it, it cannot be infructuous.
Just a minute. Just a minute. When tender notice issued?
Tender notice was issued, my lord. Your losses kindly say on 27, my lord, 27, 2022.
22. For how long?
That period has not been mentioned, my lord.
1 year.
1 year.
And next 2 months.
They have work period for 1 year. They have said that carrying work period for 1 year, my lord.
1 year.
The which period they have not mentioned, my lord. At page 17.
Period is not mentioned, so 1 year can, since the day you started working, 1 year can't be counted from that.
No, from the date of
Because that's the date is
no,
not working.
my humble submission before lordship. From the date of allotting the work, it is for 1 year, my lord. Allotment has not been done. I have checked. I am working on basis of previous tender, my lord, not on the basis of this tender, my
We
lord.
understand.
It is a fresh tender, my
We
lord.
understand that.
It is a fresh tender, my lord.
Yes. Where is the tender notice?
Notice it under Annexure 1, my lord. You lost this kind. Annexure 2, my lord. At page 13, my lord. The e-procurement notice was issued on 2022 And your losses kindly come to page 16, my lord.
No, we'll come not see any other.
Then, my lord,
Where is the interim order?
interim order is
Connected matter, my lord.
another matter, my lord.
On
That
the
is
connected
regarding
matter.
cancellation, my
single bench.
contract that I have challenged. This is before honorable single judge, my lord. That has been connected only for reference, my lord.
No, the interim order is there
Mm.
in that case.
That case, interim order has been passed. That has been come for reference, my lord,
No.
before lords.
Like same something.
Well, that is WPC number 24316 of 2023. That is a tender. It was invited in the year 2008. I became the lowest bidder.
Just a minute, just a minute. WPC 4316.
24316.
This was in respect of which tender?
That is 2018 tender, my lord.
2018.
Yes, my lord. There I was.
Just a minute, 2018.
Yes, my lord.
This was for what period?
That is the period they have not fixed. They did not fix the period, my lord. They have been working, and all of a sudden they can contract. That contract was signed, agreement was signed. Cancel my agreement. Therefore, I filed the writ petition before the honorable without following natural justice. They cancelled, my lord. Therefore, honorable single judge granted stay operation of that, my lord. Not that. That matter has nothing to do with this matter, my lord. This is a fresh tender inviting for the future sanitization work.
So this future was from after the award.
But no, our work has
With respect to the same work.
same
My lord.
sanitation work in the same municipality, my
All
lord.
right.
That the work has not been allotted to that the successful bidder.
So you will continue for eternity.
For indefinite.
Not
period,
even,
is it
not
time?
independent. Let it be decided. If I will be the
Further
successful
tender.
pilot, I will let me complete my. If I will be a successful tender here,
Nothing,
my,
nothing, nothing.
Further tender.
But here it is a fresh tender, my lord. My tender has been technical bid has been cancelled. Your losses can come.
Nothing.
My your losses can come to that fresh tender.
No, no, I will not see. We will not see.
My lord, they have
Yes.
cancelled, but they, my your losses can have a bear with me for a moment. I was working on the basis of a previous tender. Agreement was signed. I was working here. Then they invited a fresh tender from the concerned farms that who will take over the sanitation work of that municipality. 13 tenderers applied, 13 bidders applied. Out of 13, 3 bidders become the in technical bid found to be suitable for financial bid. My bid was, my lord, in technical bid said my application was found to be considered for financial bid. As the chairman's brother's firm was involved in the tender, on fifth ground, they have cancelled my technical bid on the plea that irregularly I was paying the EPF of the employees, my lord, which is not correct at all.
So what you have continued with, they will come out with fresh tender.
They
will come out with fresh tender now.
They will
No,
come
my
with
lord.
the fresh tender, my lord. I have no objection.
Yes, yes, they'll have to.
Yes,
Very
my
good.
lord. Your
They'll
lordship
have
say
to.
that your lordship may observe that.
Yes, yes.
May I please, my lord? My lord, in the connected writ petition, my lord, may we see the order of this honorable court, my lord. This honorable court has specifically directed whether I am the successful tender, my lord, whether I am successful tender or not, that has been specifically questioned, my lord.
No, but that,
Man, that is my lord, that is connected matter. But that I don't. 10/2023, my lord, maybe order may be seen. 4/10/2023. Specific question was asked to the municipality whether yes, I am not in party in that case. I am intervening in that case. My lord, coordinate has specifically asked whether I have been participated or I have been L1 or that particular to that question is I am reading that para 4. Order number 4/10/2023, my lord, connected matter, my lord. That is 24316 of
That
2023, my
will be
lord.
decided by honorable
I'm
single
reading.
judge.
My in view of
That will be decided by honorable single judge.
my lord, single judge, I specifically my
that
directed
will
in
not be
para
decided
4,
by a single.
para 4.
That is
I am
attachment of
reading,
honorable single judge, my lord. That's connected. That will be decided.
Therefore, this court has no jurisdiction. Don't make such submissions.
No, that
Please.
I can't say. I can't say, my lord, your lordship. I cannot say because your lordship is the master of the roster, my lord. I cannot say that your lordship has no jurisdiction at all. My humble submission, that is the honorable single judge assigned matter, my lord. Let it be decided whether, my lord, the contract was
not write
cancelled properly or not.
We should not write orders in your presence.
My lord, what sin I have committed, my lord?
Stand
My lord, what sin I have committed, my lord? I am not, my lord.
Please don't compel us to comment on your conduct.
My conduct, my lord.
Yes.
My conduct is not, I have not done anything, my lord. My conduct is bad, my lord.
Yes. One day orders. Yes. What do you want to say?
4/10/2023. I am reading that question, my lord. This honorable court has asked, in view of the disputes and the facts that no document could be placed on record to reveal the intervener as the successful bidder. The municipality, that is the executive officer, Pottamdai municipality, is directed to file an
So let there
affidavit
be fresh tender, Mr. Consul.
my lord, that affidavit has specifically filed that I am the L1, my lord. That affidavit is in that record, also in record, my lord.
All right. Yet the was only for 1 year.
The period was, my lord, due to interim order. Due to interim order, I have been suffering, my lord. What happens, my lord? What happens? Get a glance.
Did you make any application for vacating the order of stay?
My lord, one
Did you apply for vacating the order of stay?
My lord, my one submission, my lord, to their certificate, they have suppressed the present writ application has been suppressed by the petitioner. My lord, affidavit may be seen, my lord. The affidavit in the present first one case, in the affidavit in the clause, the matter of which the present writ petition, where interim order has been before that interim order is taken, that has been suppressed in the writ petition. The coordinate bench has asked specifically, and how it is a single bench matter gone to single bench.
Suppression of facts.
So,
The
the suppression of
fact
fact,
finder has
any
not
interim
mentioned in certificate.
that has been in a certificate. Both 3 matters has been taken, but present interim order has not been knowingly taken. Writ petition has not been taken.
Technically,
The conduct of is very much conduct of the writ petition issue. Interim order taken since long.
That was assigned by no single judge. This is the fresh tender matter. I challenge the fresh tender matter.
In a 2018, that is a tender for 1 year. In agreement to a tender, further tender was done. I am in L1. But in a single bench or interim order, I have been deprived, my lord. That a specific affidavit has been taken in single bench order also.
My lord.
If my lord fresh tender is your lordship.
We don't know what will you do.
Item number 2.
Item 2, this matter may be taken up tomorrow. I will take instruction.
Tomorrow we have difficulty, next week. He wants to settle the matter outside the, somehow he wants, let it be next week and Monday.
What is this matter about?
That matter, my lord, this is regarding that an order is passed. We have complied. So the contempt is filed. That's it.
All as requested. Oh,
Yes. So I want to try to solve it.
all right. As
Keep it to Tuesday coming.
jointly requested on behalf of the parties, list this matter on Tuesday.
Item number 4.
My pleasure, Lordship. But this is that matter when the staff nurse granted for study leave, but that was treated as extraordinary leave. Therefore, I have approached this honorable court that study leave is to be granted for pursuing my MSc nursing course. Last occasion, Lordship, after going through section 179 of the Odisha Service Code, wherein there is a clause that the save in very exceptional cases, study leave will not be granted to a member of service. 179 of the Odisha Service Code that deals with grant of special study leave, and 179 B note. That note says that save in very exceptional cases, study leave will not be granted to a member of subordinate service. Therefore, last time Lordship directed me to take instruction whether staff nurse is a subordinate service or not. It is a subordinate service. What Lordship is saying is correct. But that was taken care of by a government resolution that I have annexed to my rejoinder affidavit at annexure 15. Rejoinder affidavit. That is at page 13. Rejoinder affidavit to the writ application.
Writ application.
Writ application. at page 13. Annexure 15. You also got it, notes?
Annexure?
Annexure 15, 1-5.
Yes.
1-5 at page 13. May I place it, notes?
Yes.
Yes, nurse. That is, subject is grant of study leave in favor of nursing employees prosecuting higher study. I am a BSc nursing prosecuting for MSc nursing course. Nurse. Nursing has a considerable role in healthcare management system in the state to meet the challenges of multifarious health problems and critical diseases. Qualified and skilled nursing personnel are required in good number. In order to address the dearth of highly qualified nursing personnel in the state, Government of Odisha introduced MSc nursing course on self-financing mode at College of Nursing, Berhampur. The BSc in-service personnel used to go for higher study without sanction of study leave due to restriction imposed in note below Rule 179B, that which I have read just now. Note 179B of the Odisha Service Code. This acts as an impediment for the in-service nursing personnel to pursue higher study on their own by availing leave as due and admissible to them and consequent financial hardship. In order to address the shortage of highly skilled nursing personnel in the state for teaching as well as critical care management, government have been pleased to allow study leave to in-service BSc nursing
You are reading
personnel.
which page?
On page 13, 1-3.
Right.
1-3 and 15 years to my rejoinder affidavit in the writ application.
One. Yes.
This para 2, I am placing para 2.
Yes.
In order to address the shortage of highly skilled nursing personnel in the state for teaching as well as critical care management, government have been pleased to allow study leave to in-service BSc nursing personnel to pursue postgraduate study for a maximum period of 2 years. Every year, not more than 4 in-service nursing personnel will be allowed such facility, and these personnel will be selected by a selection committee comprising Director Medical Education and Training Odisha, Director Health Services Odisha, Director Family Welfare Odisha, and Under Secretary Health and Family Welfare Department will be convener of the committee. Candidates who have already availed study leave for higher studies will not be reconsidered. Then 2, the other instructions as stipulated in para 4 of the Finance Department Office Memorandum dated 29/7/1980 shall be followed scrupulously. Then this Finance Department Office Memorandum is the next page, page 14, page 1-5, that is answer 16.
Yes.
Page 15, 1-5. In that paragraph 4B, the relevant portion is paragraph 4B, last paragraph. The government servant who is granted study leave be entitled to leave salary equal to pay and dearness allowance admissible to him while on duty immediately before proceeding on study leave.
Yes.
This is of the year 1980. Since then, the staff nurses are going on study and they are getting their salary last paid run, that they are getting their salary with things. And in my case, my study leave was granted from 17/11/2015 to 16/11/2017 for 2 years.
17/11
17/11/2015 to
17/11/2017
to 16/11/2017 for 2 years.
and sponsored by the department. Whether you were sponsored by the department?
Yes, I am sponsored by a department. I have faced an interview conducted by the department.
No. Sponsored and interview, these are two different things.
No, I am sponsored by
The entire
Yes.
expenditure was met by the government.
Yes,
Department.
yes.
Entire expenditure was met by the department.
My lord, I'll reply to that. Let him complete, I'll reply to that.
The sponsored means it is not self-financing.
The department had sponsored, the department had paid the your tuition fee,
The tuition fee department has not paid.
Then
Because I am being selected by a selection
Alright.
committee, as the resolution says, I have to be selected by a selection committee formed by the government. A high power court that has been selected, thereafter my name was recommended and study leave was granted. The resolution says that I have to be selected by a selection committee.
All right.
The committee has
But they were not sending you, so you came to this High Court and obtained an order.
No, after my selection, they say, since you have not completed 5 years of regular service, we will not allow you to join. No objection certificate was not given. Therefore, I approached this honorable court that I may be allowed to go because I have completed 5 years of service, regular service, but my regulation order has not been issued.
So
Therefore,
therefore-
this honorable court granted interim order, you allow him to go on study.
Therefore, you were not sponsored nor nominated.
I-
You wanted to go for higher studies.
Yes,
You had applied.
yes,
You were selected also.
yes.
You can go, but it is not that you were sponsored or you were
So
nominated.
they have to give me a no objection certificate by the government, you go and study.
No objection certificate means they did not have any objection, you going for higher studies.
Yes,
That does not amount to this
That also they had not.
nomination or
That also government had not given because the services had not been regularized.
not been regularized.
So after he went pursuant to order of this court, a regularization order came with
From-
effect so and so. So so the regularization order came after you had completed your training.
yes, but with effect from the date I have joined, originally joined.
But this
That is the rules itself. That rule is, I will place the rules. The rules
office memorandum is
say,
against you.
My
This
lord-
office memorandum is
Yes.
against you.
which of the this
29/7/1980.
29, yes, that says B, I am placing a B, a government servant who is granted study leave will be entitled to leave salary equal to pay and DNS allowance admissible to him while on duty immediately before proceeding on study leave. So they say it has to be followed and study leave is to be granted within all other persons, everybody has been granted.
Right?
Everybody, those who have gone with me, they have also been granted. Those who have joined along with me, they have been granted.
We will see.
Now there are only objection in the counter on by the government that I have not completed 5 years of regular service. That has also been clarified that my contractual period is also to be taken into consideration for the purpose of calculation of 5 years. That is annexure 12. That is the only objection they have. No one they have. That is annexure 12. You also can see annexure 12.
Yes,
Page annexure 12. Minutes. That is at page 7.
Yes.
Page 7 of my rejoinder affidavit. Page 7, annexure 12. That they have calculated. They have also page 7, annexure 12. Have got it? Let me place the pursuing higher studies by in-service nursing personnel. In continuation to this department notification dated 2020, after careful consideration, the government have been pleased to allow the past service of the staff nurses, those who have already been regularized on completion of 6 years of contractual service. The contractual service period will be treated as government service for the purpose of computation of 5 years of regular service under Rule 180 of the Odisha Service Rules for grant of study leave in their favor. This has been concurred by the Finance Commission. And they say 5 years of service, that is to be considered for computation of 5 years. That contractual period is to be taken up.
So when were you granted leave?
I was granted leave from 17/11/2015. That is, the impung order is annexure 6.
No, but this, they were not knowing that in 2020 August, there will be some communication by the government of Odisha.
Now that has been clarified. That is a clarification given that the 5 years of contractual period is to be taken into consideration. That is a clarification to 180. That is clarificatory.
No,
And
this is not
It is
clarificatory.
not the first time.
This is not clarificatory, Mr. Counsel. Please read.
And
So this is for the first time.
no, this is a clarificatory And this rule says, I'm placing the rules here also. Can I see the rules?
Mr.
rule-
This is not clarificatory.
This annexure 12.
Annexure 12.
Annexure 12, in continuation to this department notification so and so, after might have been pleased to allow the past service of the staff nurses, those who have already been regularized on completion of 6 years of contractual service. The contractual service period will be treated as government service for the purpose of computation of 5 years of regular service under Rule 180. This Rule 180 says 5 years of service. That has been clarified. Also, I am placing the Rule 180.
Mr. This was issued in 2020, and for the first time it was decided that after government has been pleased to allow past service of staff nurses, those who have already been regularized on completion of 6 years of contractual service.
Yeah.
Then
Under
contractual
Rule
service will be
180,
treated as government service for the purpose of continuation of 5 years of regular service.
Under Rule
the
180
study.
also. So Rule 180 has been clarified that 5 years of contractual service under the government. That is page 379. That Rule 180. Extra leave on half hours pay for the purpose of study leave. The extra leave on half hours pay for the purpose of study leave may be taken either in or outside India. Study leave will not ordinarily be granted to government servants of less than 5 years of service or to government servants also. So those who have got less than 5 years of service, and so the government servants having less than 5 years of service. Ordinarily, they should not be granted study
You are
leave.
reading which rule? 180.
180, sir, 180. Page 379.
Extra leave.
Yes, extra leave on half hours pay for the purpose of study leave. In that clause, it is indicated that extra leave on half hours pay for the purpose of study leave may be taken either in or outside India. Study leave will not ordinarily be granted to government servants of less than 5 years of service. That they are relying upon. That
No,
since
but where had you gone for your higher studies?
this in Barampur, I am placed in Barampur, in the district of Barampur. I have not gone abroad or anywhere. I am in Barampur itself.
So you are claiming half average pay.
No, they will pay that. They say extra leave on. It is not extra leave. It is leave, study leave. So, but they say 5 years, unless 5 years service is there, no leave will be granted. That they are relying upon, saying that extra leave on half hours pay for the purpose of study leave may be taken either in or outside India. But study leave will not ordinarily be granted to government servants of less than 5 years of service.
This study leave will have to be read with extra leave.
179 is study leave.
So they are relying upon this for the purpose of saying 5 years service, you don't have 5 years of service. They are relying upon this. Extra leave. But they are saying that this leave is also be leave. Study leave will not ordinarily be granted. So study leave, they say.
This study to be read with this. No, this study leave will have to be read with this. So, under now that previous sentence will have to be taken. So this is study leave, not this study.
You are saying what was there, study leave will not ordinarily be granted to government servants of less than 5 years service.
Service. They are saying that their submission. Yes, that is their case. Since I have not completed, I will not be granted. Yes, they are relying on that.
Subsequently, it was said that if we have not also worked on regular basis, that period will also be counted for this 5 years.
Yes, if I am appointed by the government on contractual basis, that contractual period is also be treated as government service.
Everybody who had done that.
Yes, that is a rule. That is a rule itself. I am placing the rules. The rules under which I have been regularized. That the rule says
We are talking that notification or letter which has been issued by the government. Will it apply to all the study leave that has been taken?
See, you may be granted leave, but the only question is whether you will be entitled to salary for the period or not.
Yes.
That is the question.
Even if before this clarification is made, they all granting to other similarly placed persons.
Maybe grant of leave.
Yes.
And payment of salary during the period of leave. These are two different things.
They are granting. They were granting.
So they were granting. That's a difference.
Yes.
If they were committing some illegality, they are not required to be forced to do the same illegality.
So no, I will be.
We'll have to. We do not find any provision which entitles you to get salary for the period of the study leave. Unless you can get if you are sponsored or if you are nominated. You have not been sponsored, you have not been nominated. We are coming back.
Yes.
Your written notes.
Only one thing I want to place that after completion of my 6 years of contractual service, under the rules I have been regularized. The rule says the moment I will be regularized, my government service will relate back to the original appointment date.
You may be entitled to leave. The question is whether you are entitled to salary or not for the period.
Yes. So to that, my submission, I have been sponsored by the government.
Sponsored by the government, there is no document.
Sponsored means that resolution says I will be allowed to go on study leave provided I am selected by a committee constituted by the government.
Yes.
I have been selected by the.
Selection does not mean nomination. Sponsoring. Yes. Give your side.
What you were saying about those 2 persons who stand on similar footing.
Yes.
If I am not mistaken, they were sent for training after they had been regularized.
Yes. My case is on the same footing because I have filed a case and this honorable court has intervened and directed the government to allow on the basis of the and my regulation also from the retrospective.
Parties shall be at liberty to file their written submission, notes of argument by next week. Yes.
Item number 5.
By Monday.
Item 5, my lord, on behalf of Mr. Mahapatra, my lord, there are total 6 cases, my lord. There are total 6 cases. In the main case, my lord, WA number 2267 of 23, in order dated 26/2024, my lord has directed to pay rupees 20,000 to the petitioners. The condonation of a delay, my lord. We have already paid. Regarding that, we will file a memo, my lord, today in course of day, my lord. And there are 2 other matters also there. That may be tagged off, my lord, to that case, those cases.
They are also barred by limitation.
Yes, my lord. Similar to same, we have filed on the same date, but those matters are not listed till.
All right. Learned counsel, same order.
Same order, my lord.
They arise out of the same order.
My lord. Yes, my lord. That order dated 26, order dated, my lord. No, my lord. Till not listed, my lord.
No, whether in those cases delay has been condoned or not?
No, my lord. No.
And how can they be listed along with us?
My lord, same order.
At least thrice. Why have you not mentioned earlier?
We have mentioned earlier, but not listed. My lord, there are those 2 matters left, my lord.
First.
Unfortunately, those 2 are WA number 2393 and WA number 2403 of 2023, my lord.
So how many cases are there?
6 cases, my lord.
Give a list. So we have mentioned then we missed out all. No orders to list with other matters.
There is no, and there could not be any order because they were barred.
My lord, on the last occasion, they did not mention about any other matters.
Yes, that is what we are telling him. So have you filed it last week?
No, my lord, we have filed it in
Did
18-9.
not mention, matters have been listed at least thrice.
Yes, my lord.
Already, my lord, filed on 18-9-2023, my lord.
Just along with that.
What is the case number?
My lord, WA number 2393 of 23. And WA number 2403 of 2023.
2404.
2403, my lord.
The matters will have to be listed for. This is where. Patnaik.
Yes, my lord.
My lord, these are all, I may be pardoned, my lord, these are all regularized matter. They are all poor employees, my lord.
Seeking time.
Miss Patnaik, the matters.
Yes, my lord.
My lord, these are, yes, my lord.
You have appeared for, I think, all the respondents in these cases. So you
Yes,
take
my
note
lord.
of those numbers if you were
The
appearing
new-
for them.
New cases, they have just now mentioned, my lord. We have to verify whether we are appearing or not. But in all other cases listed today, we are for the respondents. They are poor employees, gardener, watchman, sweeper of the university, my lord. Their regulation have been ordered against which they have come up in appeal. Your lordship may kindly fix a date for hearing.
These matters. What is this matters on? Monday along with WA number. Thursday. WA number 2393 of 2023 and
2403, my lord.
2403 of 2023 to also arise out of the same impugn, same judgment of the learning single has been under challenge in present set of appeals.
Same common judgment.
My lord, my lord.
Also.
Yes.
I hope there are no other matters.
No, my lord.
Yes.
Only these 6 matters.
No, you are not.
Item number 6.
Obliged.
Yes.
May I
Something
please,
could
my
be
lord?
done.
My lord, in this case, I was told to take instruction as to what to do with the valuation of the flat as on date. My lord, my instruction is the valuation of the flat would be 71,85,000 as on date. And for the arriving at that, we have taken the valuation report from 3 approved valuers, and we have taken a average because one of the valuer is stated that the valuation would be 71,93,000, another 73,60,000, and another valuer said 70 lakhs, and we have taken an average, and that would be around 71,85,000.
I have got myself, my lords, calculated through a chartered accountant, registered chartered accountant. As on 31st July 2024, the valuation comes 48,73,405. I'll file that report by affidavit, my lord. Let him file his calculation by affidavit so that we can
No, why should we? We should decide the appeal.
We were thinking that if he gives an amount and you are agreeable, then that matter can be disposed of.
Yes, madam.
Since that is not possible, we will hear on merit.
Yes, madam. The chartered accountant's report is 48,73,000 as on 31st of July 2024. Though the Honorable Court directed on the date of judgment, the amount is to be calculated. However, my lord.
Date of judgment?
Yes, my lord.
That calculation must have been done on the basis of the direction given by the Honorable Court.
Yes,
the
my
Honorable
lord.
Court said that with 6% interest, and that comes to we have also calculated it. That comes to 46 lakhs 25,000. But your lordship wanted as to what would be the valuation of adjourned debt.
Your lordships wanted to know what will be the amount cost as per the Honorable Judge, Single Judge valuation on today.
That could not be the order. Let us see.
Your lordship, the order is.
Let us see the order.
No specific order was passed, my lord. Your lordship just wanted me to take an instruction.
Yes.
Otherwise, there is no question of challenging it. We could have calculated.
That we don't have any necessity of asking, because if that is the order, if that is complied, we don't have anything.
Yes,
to
that
do with
order is
that.
under challenge. And as on date, my lord, the 3 BHK flat, as your lordship, it will be more than crores. But since it was a bold one, we have taken the depreciation value and calculated it. And we have taken the report of 3 approved and we have done an average.
All right, we will decide. We will decide it then.
Yes, sir. We'll make a set.
What may?
My valuation, they said that 76 lakhs.
No, settlement you have to do. We can't do the settlement.
Yes, my lord. So my lords give. My problem is I have been writing them. They are not giving me a chance of making a settlement.
We will see whether this. See, we have to see the legality of the order, correctness of the order. We will decide that. We will decide how correct the order is.
That order, my lord.
Yes, we will see. See, we have already.
Your lordships have already expressed the opinion. If we must be because that is their valuation, this is my valuation.
So there is no question of any conciliation. So the gap is so huge. So therefore, we will decide it on merits. That may go in your favor. That may go against in his favor. Council proceeding. Okay. Let me do this.
Your lordship to hear the matter.
No, we have already heard. We will decide whether.
We have reserved the order judgment. They have come up challenging the order of the learned single judge.
Should I?
Since you did not arrive at a settlement, it will be the judgment will be on merit.
My lord, with regard to my contention, I am just relying on the judgment of the Honorable Supreme Court in the case of BDA and other parts.
If your lordship will permit me, I will file the calculation.
Where is the question of calculation? It's a question of law.
Calculation, if you would have settled the matter, it is.
Yes, sir, but they did not give us a hearing. That's what. Otherwise, you were ready. We have requested them number of times. They did not give us a hearing.
No hearing.
They did not give us a date for a settlement also, my lord. That's what my specific case
You
is.
failed. You failed. Your client did not realize the importance of the court's observations. Yes.
Item number 7.
My lord, may.
What he is saying, the market rate will be like this, but because at that same rate they have considered.
My lord, whatever the because your lordship wanted to know, he has told it today. So definitely we will be trying to make a agreeable to that. My lord did not go for a judgment.
So you want
because
so you want to consult your client and
yes, my lord.
As requested. Counsel representing the appellate has submitted that based assessment of key valuers, value of the flat in question has been found to be, has been calculated as at 71,85,000. So stop. Learned counsel for the respondent seeks adjournment to concern to consult his client and make submissions accordingly on the next date. This case on 1 week within first trial cases.
1 week.
10 days, ma'am.
10 days. If yes, otherwise we will decide.
Yes, ma'am.
Item 7.
Item 7, I am pardoned, my lord. Das, supposed to argue the matter, my lord. He is on his, Mr. Das Learned senior counsel supposed to argue the matter. He is on his legs, my lord. I am praying for tomorrow or tomorrow.
Item 8.
Inconvenient, my lord. I have some assignment. Maybe day after tomorrow.
Day after.
Lord, item 8.
Just may see the last order in item 8.
Item 8.
Yes.
You have given the, which is, he has himself measured, he has said 175.2, which will retain the mark, which was originally awarded to him.
Which order you are referring to?
Lord, the last 20th August 2024.
Which item is this?
Eight,
The item 8. So now we have 3 heights. We have
What?
3. Now we have
Three
3 heights. So he has grown or height is reduced?
No, the original first time
First was
178.5, then they remeasured it 174.5 and
174.5.
5. And
Now
pursuant
he
to
has
his lordship's
grown.
action, he has given his own measurement, which is 175.2, which will come within that 175 to 179. So the original mark will be retained if that is true.
Now we had asked him to see if he is being honest, not that his
No, I
height
fully understand
gospel
that.
truth.
Even I had asked him because I have told him that the first thing that will fall from the court would be this question. So he said it's about 176, but in any case, I am more than 175, which is covered.
Oh, about 176, but actually 175.2.
5.2.
Have you filed affidavit?
Yes, my lord. I have given the affidavit to the oath commissioner. I deliberately asked him to get it done through the oath commissioner, not through any notarized.
Before that, you should have measured him.
So then, what is the system here in Odisha High Court of affidavits being sworn in before?
Oath commissioner also, as well as notarized also something.
It's not permissible under the High Court rules.
That is being accepted, my lords, as a practice from the
Hey, Delhi High Court.
This is before the, my lord, oath commissioner.
This is the oath commissioner, all right.
No, I just.
Yes, my lord. Just.
Whether that affidavit is there? When did you file?
No, my lord, I have given to the court, my lord. Just,
Today?
Yes.
Yeah.
So this is an admitted fact that that was incorrect. The
First one. Even the second one is also incorrect. What they also second
Incorrect
one.
as per his measurement. So
Maybe, but they are the authorities.
But in fact, as per his measurement, he comes, if he is 175.2, if it is measured, then the marks will remain the same as earlier.
That is why his height is 175.2.
Lord, what I was in fact proposing, subject to your lordships, that let an independent this thing,
Would you
because
be
it's a matter of his career
What
also.
do you mean
that-
independent? Are you saying
No.
the officers have something against him, so they will give a
No,
less
because
height?
there were three measurements done by them.
Huh?
First stage, they did the measurement. Then second stage, when the like documents were to be verified,
Not them.
again at that point of time by them.
The
Then third time,
the type of measurement that will be done in the field, that is different. That is why there were complaints that the measurement is not proper.
no, but they had not given that reason also at any point of time. That's why.
I think the affidavit says that
No,
those are the
later on,
complaints.
Lord, after I gave the representation disposal order was passed, then they gave the reason that it was less, and then second writ petition, they filed the counter affidavit. In the first one, they didn't say anything about that.
Had they filed a counter?
In the first writ petition, my lord. No, first writ petition, there
Then
was
how
no.
can they give?
No, but then they had not given also any reason by that time.
To whom?
To me, to communicate why I have been rejected, because my name was in the select list.
No, but there's the mentioning of your height as 178.3 was apparently a clerical error.
That's what they said, typographical error.
And your height was taken and that was found to be 174.5.
Fine.
So did you state in your writ petition that correct height was mentioned initially?
No, I have not said that. I've said that the selection board, once they've done the measurement, the subsequent, during the verification of documentation, there was no further occasion for them. So just to cover up that, they have mentioned this, because they have not given me any reason.
Another thing, if your height is 175.2, 178.
That is also wrong, but the marking will remain the same, because that's 175.
That is not
to
the question. The question is,
I
you
understand.
also did not
Say that height is
take
wrong.
this stand that in the writ petition you could have mentioned.
That actually, though my height is this, by mistake it has been mentioned, it will
I
make a
understand.
difference.
All right. Pass orders. 2 weeks orders. We will decide.
Your lordship will take up but,
Orders, we will pass.
or
Yeah.
the lordship's
yeah,
permit,
but
I
which
can
is
give
taken
a
out.
one-page note so far as the regulations are concerned, so that Lord, that will confine the issue.
Item 9.
It's in item 9, your lordships are pleased to item 9, it's a public inter litigation. The lordships are pleased to direct me to file a reply. In fact, the allegation is that they need a minor irrigation tank to be excavated in that locality, and for which rupees 12 lakh has to be sanctioned. Now, instruction, the process of the amount being sanctioned, and it will be covered up. So I've got the instruction, I'll file it an affidavit so that the lordship can dispose of.
No, let us see what is this PIL. We can.
PIL is lords.
What is your instruction?
No, my instruction is that in fact 12 steps are being taken for sanction of the 12 lakhs, which the petitioner seeks in this PIL for construction of that minor irrigation project. So lords may grant me some time so that I can file that affidavit. That amount has been sanctioned, and because it's for irrigation purposes, lords. And the collector and authorities have decided to have it, lords. Have it in that locality.
Then we can dispose it off. In the light of the stand which you are
Yes,
taking,
yes.
you can dispose it off with observation. All right.
Yes, lords.
How much time will that take?
4 weeks time, your lords may say.
No. How much time will it take for completion of the work?
Project, I don't know.
If you don't know, don't say offhand.
No, I say amount will be sanctioned within 4 weeks, and thereafter the project will be taken up by the authorities, because it's under the not under the minor irrigation department, it's under the collector himself. Because it's an existing tank, so the capacity of the tank has to be raised so that irrigation can be given to the. It's a tank already there,
Tank means pokhari or what?
Pokhari, bada pokhari.
Only that they have to develop.
Store
Yes.
rainwater. Rainwater
Rainwater.
means store.
Present writ application in the nature of public interest litigation has been seeking direction to the opposite parties to take necessary steps for construction of minor irrigation project minor irrigation project in village. Villages Talpali.
Talpali, my lord.
Talpali and Jankada in the district of
Bargad. Bargad.
Bargad. Bargad. First off, it is the petitioner's case that a little stream called Milken Mulla.
My lord.
Milken Mulla flows by the side of Talpali and has been selected as an, what is MIP?
Minor irrigation
Minor
project.
irrigation project site. For Talpali and both the villages.
Both the villages, Jankada
Talpali
village.
and
Jankada.
First off, there had been demand of the people of the two, the residents of two villages for construction of tanks to convert it.
Your lordships, lords, tank is there only for deepening and widening of the tank that they are demanding. Lords. Page 4, they have stated that deepening and widening of the tank. Lords.
For deepening and widening of tanks. Of a tank or so many tanks? One tank.
One
Water
tank. Lords.
The tank.
Of
only one tank.
That is, two tank are there in that village.
the tank located in village Talpali. So as to convert it as an minor irrigation project. Full stop. It appears that on physical verification, a recommendation was made for release of fund by the additional district magistrate Bargad.
My lord. Also, collector also recommended, my lord.
And the
page 23.
And the collector of
Bargad. Annexure page 23.
Stop. Next. Mr. Samantral and AAG, appearing on behalf of the opposite parties, has submitted that he has received instructions to the effect.
Before you lost, Mr.
Received the instructions from OP number 4 to the effect that a sum of rupees 12 lakh
has been requested to be allocated for the said purpose.
Has already been requested to be allocated for widening, deepening and widening of the tank. First off, he has submitted that in policy, the opposite parties are of the view that tanks should be deepened and widened. for catering the irrigation needs of the two villages. Full stop. In such view of the matter, this writ application is disposed of with an observation that let concerned opposite parties take sincere efforts to ensure that the concerned minor irrigation project is completed within a reasonable period of time, preferably before the ensuing summer.
No, during the summer, because after the rainy season, they will, because water level, because it's a 15-acre tank, not big tank.
Oh, 15-acre tank.
15-acre tank.
Within a reasonable time.
Reasonable period. In between, you remain alert and see that they are doing work is
Yes, Lord, I will say that.
And in some places you have written panchayat instead of village. So it is village or panchayat?
This is both are one panchayat.
So
Two villagers are benefited. Two villagers are benefited in this.
No. In some places in your writ petition, instead of village, you have mentioned panchayat. That's what I was asking. So villagers' names is all right. Village name.
Two villagers coming within one panchayat.
Yes.
Item number 10.
In this case, my lord, on 21st August, we have filed counter affidavit through e-filing, my lord. I am filing hard copy. And I am also solving copy too.
Yes.
And I also solved a copy of the counter affidavit to my learned friend.
1 week time may be given for filing a rejoinder.
Counter affidavit is said to have been filed online on behalf of the opposite parties. Stop. A copy of the said counter affidavit has been served upon learned counsel for the petitioner today. Stop. Learned counsel for the petitioner seeks adjournment to consider the said counter affidavit and file reply if so required. As requested, this matter on when?
Next week, my lord. Next week.
1 week.
Item 11.
My lord, date may be fixed.
1 week means 1 week.
Month.
Will come.
Item 11.
May I please, your lords. Lord, item 11, I received the, my lord, counter affidavit, my lord, 10 days time to file rejoinder affidavit.
Same order.
Oblige.
Item 12.
12, your lordship, we received the paragraph yesterday, 2 weeks to file the counter affidavit.
In which is 12?
12, my lord. Sort.
Obliged, your lordship.
4 weeks. How much time?
Yes, your lordship.
How much time? 2 weeks.
2 weeks, your lordship.
2 weeks time is allowed for the opposite parties to file counter affidavit.
Obliged, your lordship.
Item 13.
Tomorrow.
Item 15.
13, 14.
May it please your lordship. My lords, I am on VC, my lords.
Item 15.
My lords, lordship, I directed my learned senior to take instruction, my lords.
I am for the opposite parties. I need another 2 weeks time to file the counter. Lordship asked me to take instruction. I have received the paravised comments. I need another 2 weeks time to file counter.
It's I think the writ petition has become influxus. I don't know. I am appearing for the petitioner. I had challenged the.
You are saying then who are they to? You are for.
No, I'm saying I have filed.
There are 2 writ petitions, your lordship.
I'm filing a memo to that effect. I'm just.
Lords.
Just your lordship may give me some time.
My lords, there are 2 writ petitions, my lords.
Now what has happened, your lordship? The writ petition that is a serial number 2, which my learned.
The second matter. I'm appearing in the second matter.
That is 185.
Second has become influxus.
This
But
also,
there
this
had-
first read petition also.
Tell us why, tell us why.
But
I'll tell. May I tell your lordship?
No, you cannot.
the petitioner had filed the writ petition challenging the award of work in favor of opposite party number 3. That was for 365 days, annexure 2. So by efflux of time, it has now a fresh tender has been floated for 1095 days. And we have all, both of us have participated in the tender. So there nothing remains to be decided.
So you,
The first tender, the first
so
read.
this is your junior is not here.
Lord, that's right. I'm filing, just give me 2 minutes, Lord, sir. I'll just
Yes,
file
there
my
is
memo.
no petitioner
I've given the new NIT.
He's in VC.
My lords, I am for the petitioner in the first
There
read.
are 2 cases.
My lords.
Which case, according to you, has become infructuous?
Second case. The first case, I am not a party. They have not made me a party.
So first case.
My lords, in the first case, I am for the petitioner. my lords.
Second case,
No.
when senior counsel appearing on behalf of the states that
Your Lordship may mention that I'm filing it just.
that the application has become infructuous. A memo to the aforesaid effect is being filed. Of this application and disposed of as having become infructuous. Yes.
Was there any interim order?
No,
Was there any interim order?
No interim order.
That's why it became.
The first one survives or that also?
First
Yes,
one,
First one,
by
lordship.
the instruction received by me, the first one emanates from the second writ application. In the second writ application, my learned senior LO issued to the petitioner in the first writ application.
So first, in the first state application, who is appearing?
My lords, I am
Petitioner is
appearing for the. My lords, I am
Yes.
appearing for the petitioner in the first, my lords. My lords, if the second writ petition becomes infructuous, my lords, then my lords, there is no impediment in extending our work order for the next year, my lords. But my
Provided
lords,
1 year has not expired.
No, 1 year.
Now what has happened is, the time has expired.
No, new NIT has.
May I
been-
submit your lordship? Now what has happened is, the time, the second writ application expired, that was for 1 year. Now we have issued an NIT for 3 years for the self-same work, and the petitioner has participated in that tender.
Petitioner and the
Petitioner and the petitioner in the first writ application,
As well
the
as-
second writ application, as well as the petitioner in the first writ
So it is
application, both
open.
have participated.
He may not press participate in
my lords, no, my lord, the first writ petition arising out of a tender, which was for 3 years, I was given a work order for 1 year subject to the satisfaction of the MCL authority, and therefore, after completion of 1 year, they have given me a certificate of excellent and outstanding work performance. Then they filed an application before your lordship to permit them for extending the work order, my lords. So far as the second NIT which has come in between, which my learned senior is submitting, is no way connected to my writ petition, which is in.
I'll file a counter to
So
that.
therefore, my lord, lordship may keep it to next week, my lord, so that my learned senior
Lordship may give me 2 weeks time, I'll file counter.
If you submit the present NIT is as good as same as that of this one, my lord, then my writ petition will become infructuous. Otherwise, as in date, it is not.
I have given a copy of the new NIT in my memo. Your Lordship may pardon me, just 5 minutes, I will just.
Second writ first writ application, lordship may grant me 2 weeks time, I'll file the counter with all the documents.
May I pray next week, my lords?
No, lord, 2
I
weeks time.
humbly pray, my lord, because lordship has given 2 weeks time to my learned senior. Now the difficulty is, my lords, I was supposed to be awarded 3 years work. They gave me 1 year, then they are not extending.
2 weeks.
And it is their own case that I should be extended.
Come after 2 weeks.
On 12th, actually, we had granted you to.
Malas,
May I humbly pray, my lord, next week, my lords.
12th.
malas. Obliged.
You were granted time for filing affidavit.
Now
on
we'll give
12th.
1 week.
My lords, may I pray next week, my lords? My lords, because
Yes.
I'm so grateful. I'm obliged, my lords. I'm so grateful.
Lordship is calling on 12th.
Next week, my lords.
Third.
I'm grateful.
Item 16.
I'm sorry, brother. I'm just filing.
Oh, it's all got it. Ask your junior if he is here. Otherwise,
May I pray, let it be on 4th, I will not be available on 3rd.
Fourth, Mr. Behra, fourth.
Yes, my lords. Yes, I'm obliged.
Item 16.
Item 16 may be taken up 10 days after, my lord.
he has paid for NOC for different process.
In one writ petition, different.
One writ petition.
Where is it?
That to 3 councils. The TMRT councils, nursing council, and physiotherapy council.
Yes, so what is your relief? Just a minute, you can hold your breath. Please sit. Please sit for a while. Please sit.
Pani.
Yes. What is your relief?
In this matter, they have in the renewal of NOC, taking admission into the courses, my lords.
So many courses
My lords.
in one writ petition.
My lords. Well, what happened there? The only reason they are rejecting they are not granting me the NOC is for want of fire safety certificate.
Yes.
Last year also, after the fire department pointed out some mistakes in the building, so we corrected it, and we have sent the building plan for approval of the PKD. Only after approval of the PKD, the fire office, Pupuri fire office can grant us the fire safety certificate. Now, for want of that fire safety certificate, they have refused the NOC. Last year also they refused the NOC, and we approached this honorable court. This honorable court directed them to verify it along with the officials of the fire department, and if they are satisfied with the arrangements, they shall grant it. Last year they conducted the fire safety inspection, my lords, and they prepared the report, and they, on the basis report, the NOCs were granted.
But last year you filed 3 writ applications. This year you have filed 1 writ application, and different authorities have to grant the permission.
And that is not one aspect. The other aspect is that if there is requirement of having fire safety certificate, and if you don't have, then you can't be granted. That risk cannot be taken.
We have applied for the fire safety certificate.
You might have applied. We don't know whether you meet
and
these
you'll also
standards or
find
not.
a glance of the inspection reports prepared by them, my lords. In consultation with the fire department, they have
sorry, cannot be done. We cannot ask them to grant you whatever recognition or permission without
safety of students.
without.
We have taken all the precautions, my lords. It is for the.
You have complied.
We have complied, my lords, and because the PKD is not issuing the approval certificate, that's why the fire department is not able. We have complied all the objections, my lords.
That was there in another case also.
Yes, my lord.
Is it
Similar-
disposed of? It is pending.
No, those are pending. My lord.
Pending, my lords.
Which
There is
date?
a batch matter. My lord. It was-
But that is a batch matter. This also is a batch matter. You made it one matter, but
Last year they have also, we have granted them a NOC
There
with
was
the
another
undertaking that they will
yes, sir, that was-
get the valid fire certificate within 6 months, and
they have to complain. Development, that certificate is not there, so fire safety is not being given. So that, I think that
they are not asking for approval of the development of
We have
they are putting us on to trouble that you accept our.
My lords, we have applied for the approval, my lords. They are not
The
granting.
application is not enough. Application is not enough.
because if your building is not in order, that certificate also can't be granted.
But that's why we complied the objections, my lord, and
Compliance
after,
is obtaining a certificate
my
also.
lord, so that is a delay caused by the state
So how many
authorities.
authorities are here?
So many.
Building authority or
IMT pharmacy, then DMRT, BPT, and then
These are the
ANM,
courses, my
ANM,
lord.
everything in one.
These are courses, my lord.
Because this one institution is running so many.
One institution, my lord.
DMLT
Last why because the petition.
File separate application. That is the same name we have disposed of number of applications.
Nursing
Pharma,
council is there.
pharma, yes.
Nursing council is there.
I think
DMLT, TM council is there, physiotherapy council is there, allied council is there.
What will you do?
Yes, sir. What's there? EMT is
So if the same authority is supposed to grant the permission, we can understand. So let's say B Pharma, M Pharma, same authority will grant.
And what is wrong? If you don't have fire safety certificate, then you can't be given.
taken all the fire safety precautions, my lord, but for want of fire certificate, because they are on last year on the direction of this honorable.
We have understood. We have understood, but first we have to approach the PKDA and there. Development Authority, right? Capital Authority. Those applications are pending or disposed of?
No, all the applications are pending for that purpose.
They are not concerned with that.
No, unless they give the sorry. Certificates are given, they give.
Sorry, and now nothing can be done.
That's my only submission, because on the basis of their inspection, they are granted the NOC last year, my lords. Those compliances are
illegal. That was wrong. That could not have been done. That could not have been done.
But that was subject to your complying.
It is not a question of satisfaction. It's a question of statutory certificate, which you must have, did not have. Then
that
every person who is holding LLB qualification cannot argue unless he has that enrollment certificate. Only because you satisfy the requirement, you cannot. We do not find any. If you want, you can approach. But we will not make any observation.
Mercy, lordship. Dispose in that, like
the petitioner has filed the present writ application directing the opposite parties to renew no objection certificates for what is DMRT?
Sir.
DM. Not even mentioning the full course name.
DMRT, BP, BPT and CGT courses.
And
and grant fresh no objection certificate for A&M, GNM courses in
petitioner
in favor of IMT School of Nursing bracketed the in favor of the petitioner for the academic session 2024-25 by relaxing the requirement of submission of fire certificate for a period of 1 year. Stop. Next. It is not in dispute that submission of fire certificate, fire safety certificate is one of the requirements for grant of no objection certificates / renewal of no objection certificates. So stop. The petitioner has not the same has not been issued. So stop. Next, we do not find any reason to relax the said requirement on the strength of submission that all measures have been taken by the institution to ensure fire safety. So stop. We do not find any merit in this application. So stop. This application is, however, disposed of with a liberty to the petitioner to approach appropriate authorities for grant of fire safety certificate.
Item number 17.
May I please, Your Honor? The petitioner here challenges the rejection of the technical bid of the petitioner, which is under Annexure 5, running page 93, and subsequent order under Annexure 9, running page 113, Your Lordship. The brief fact of the case is that the Office of the Executive Engineer, Lift Irrigation Division, Valuation, floated a tender.
When was the tender notice issued?
Notice was 6/11/2023, running page 24, Your Lordship.
6/11/23.
23. And it was date and time of publication is 22/11/2023 at running page 25, Your Lordship. And it was mentioned therein that the last date is seeking clarification is 28/11 and the closing date and time is 1/12/2023. And the point to be noted is that the technical bid opening date is 2/12/2023 at 11 a.m. What I humbly submit is that on that relevant day, the technical bid was not opened. It was opened in the month of February 2024, behind the back of the present petitioner, without any intimation, without the presence of the bidders. The technical bid was opened. Your Lordship comes to page number 5, Your Lordship. Sorry, Annexure 5, running page 91 to 101. And the petitioners
You approach the court.
Yes, sir.
You approach the court.
Yes, yes.
You were permitted to file a representation.
Yes, Your Lordship.
They were directed to dispose of the representation.
Yes, but they did not provide any opportunity of hearing.
There is no requirement of opportunity.
And they rejected it under Annexure 9, Your Lordship, running page 113.
Annexure 9 is there, and
Yes,
according to them, the experience certificate was not issued by a competent authority.
They are saying that it has to be issued by the executive engineer.
That's all.
But what I humbly submit that it is issued by the one by executive engineer. Your Lordship, kindly come to page 79.
Assistant executive engineer cannot.
Yes, Your Lordship, I'm coming there. Assistant executive engineer 79 and one by assistant engineer and other by executive engineer. 3 experience certificate I have submitted, and basing on the self-same certificate, the Bhadrak division of the LI division of Bhadrak have issued work in favor of the present petitioner, which is under.
So you want us to cancel that?
No, Your Lordship. Under Annexure 6, I have completed the work successfully, and payment has been also been done. One thing.
See, if there was a requirement that such experience certificate should be issued by the executive engineer, and required to be fulfilled.
What I humbly submit, the petitioner asks for the experience certificate. They are not saying that it is false or it is not. They are not questioning the genuineness of the experience certificate.
Maybe you may be having the experience, but whether it was required under the tender notice that the certificate should have been issued by an executive engineer.
Executive engineer, we ask for the certificate issued by the executive office of the Bhadrak OLIC, and the Bhadrak OLIC has issued the certificates. What I humbly submit is that
mentioned in the tender
Regarding
notice.
that certificate?
Certificate at page 79, Your Lordship, running page 79. Under Annexure 3, running page 79, Your Lordship.
Executive engineer is the drawing and dispersing authority, so he should have executed. 79.
What I humbly submit that the technical bid was opened behind the back of the petitioner. Had a opportunity has been given and had it been opened.
Mister, your case was considered by this court that it was opened behind your back.
Yes.
But the court disposed of your writ petition with the direction to consider your representation was considered. Now something has emerged, whether the court should interfere in that background or not.
The order said that you wanted your representation to be disposed of.
Means that the technical bid has to be opened in the presence of the executive engineer, but the same is not opened.
Where is that? Where is the requirement in the tender notice, Mr. Counsel, that experience certificate should have been issued by the executive engineer?
The tender has been floated by the executive engineer. It has to be opened by the executive engineer, presence of the executive engineer.
Where is it? Where is the requirement? Or you are saying because it is floated, then it is to be understood that it has to be
Running page 7.
And that 79 you gave is your work experience,
Yes.
not that who has to issue the work experience.
The running page 37, your lordship. Section 2, clause 3 is there. Opening of tender documents. The technical bids will be opened at 2/12.
Mister, please tell us about your experience certificate. Under the notice, who was required to? Whose certificate was required to be submitted?
And what you are showing is office executive engineer, not in presence of executive engineer. What you are
Because
showing.
when they are denying that,
Answer that question. Who is to issue?
When they are denying the thing that it has
Where is the experience clause in the
certificate?
notice?
experience clause is at 4. Page running page 37, 4. Paragraph 4, minimum qualifying criteria. There they say the bidder is required to upload and scan attested copy of the authentic record duly certified by the concerned executive engineer. They are saying.
They are saying means that is the tender
Yes.
requirement.
Yes, your lordship. The tender document has to be opened.
Mr. Mishra, minimum qualifying criteria. Even if you were present, what could you have done? Even if you are present, you have not qualified.
Their document. I have not brought it somewhere. It is their document given by the other neighboring district.
How many times will we are required to convince you that you are required to obtain? There must have been 1,000 persons who might not have applied because they did not have.
One thing I brought to your lordship notice, kindly turn to page 101. 101. When they are opening the tender technical bids by the assistant executive engineer, who is at that relevant point in time is in charge executive engineer. At that relevant point in time, he signed in both.
Sir, you were disqualified. You were disqualified. The petitioner in the present application has put to challenge an order dated 6/7/2024, whereby his representation filed pursuant to this court's order has been rejected. The dispute award of dispute relates to a rejection of the petitioner's technical bid submitted pursuant to tender call notice dated 24/8/2023.
22. What is the date of the tender call notice?
Unfortunately, the wrong typographical error. 6/11/2023. On typographical error.
6/11/2023.
Yes. Annexure 2 running page 24.
6/11, are you sure?
Yes, lordship. Annexure 2 running page 24.
And in the index?
Yes, lordship.
Index, what have you given the date?
The
22/11/2023 is the date where it was published.
Okay. So that is not the date.
No.
Petitioner
It was
had
published
earlier approached this court
for general public.
questioning the decision to reject his technical bid. On the petitioner's prayer, the said writ application was disposed of by an order dated 4/3/2024 in WPC number 4942 of 2024. a liberty to the petitioner to file a representation. First off, the said representation has been rejected, which is under challenge in the present writ petition. First off, in the rejecting the petitioner's representation, the
113.
The executive engineer, LI division Balasore has noted that the tender committee had found that the petitioner had not produced composite work experience certificate in e-tender from a competent authority as per DTCN terms and conditions. Stop. Next, learned counsel appearing on behalf of the petitioner has submitted that the experience certificates submitted by the petitioner were issued by the officials of the which department? Irrigation division?
LI division, Bhadrak, sir.
Of the LI division, Bhadrak. And only on the ground that the same were not issued by the executive engineer, the petitioners technically not to have been rejected. Stop. Next, we have the use. He has also argued that the technical bids were opened behind the back of the petitioner.
And in absence of the executive engineer.
In
And in the absence of
also the
the
petitioner.
executive engineer.
On
Stop.
which date? On which date?
Next.
In the absence of also the petitioner, it has to be open in.
Behind the back means that.
Yes.
Behind the back of the petitioner. Behind his back.
But the thing says in presence of the bidder or the authorized representative. So your representative was not there.
Because it was opened late after 2 months, nobody was intimated by the authority to that the technical bid is going to be open.
Experience is page 37. Page 37, which is our page 51.
It has to be opened on.
4. Minimum. And that opening also is just about that.
On 2/12/2023.
Clause 4 of section 2 of the tender call notice laid down the minimum qualifying criteria which stipulated inter alia that the bidders shall be required to upload scanned attested copies of authentic record duly certified by concerned executive engineer in support of such experience. First off, the petitioner had admittedly not produced the experience certificate duly certified by the executive engineer. First off, in such view of the order, in such view of the matter, the rejection of petitioner's technical bid cannot be said to be unjustified. Stop. His presence during the opening of the technical bid would have made no difference as the petitioner did not fulfill the requisite condition for in support of his work experience. Stop. In such view of the matter, we do not find any illegality in the rejection in the order dated so and so, whereby the petitioner's representation has been rejected. Stop. We do not find any merit in this application, which is accordingly dismissed. Yes.
Item number 18.
Here I filed a compliance affidavit. Not only one, there are two compliance affidavits. Contempt have filed two compliance affidavits. Last part B, that is the second compliance affidavit filed by the contempt. I would draw your lordship's attention to para 12, where they have given undertakings to send the petitioner for. And your lordship may kindly look at para 12. Para 12 at page 7. It is needless to say that all candidates should fulfill the criteria of the promotion as regards to the completion of accounts training as required under Rule 16 of Orissa Ministerial Service, Junior Assistant so and so, my lord, in the district offices and office subordinate thereto, held by the Board of Revenue under Rule 163 of Bihar and Orissa Board's miscellaneous rules before consideration of promotion from us, the post of Junior Assistant to Senior Assistant. In the instant case, necessary adequate action is being taken to complete the accounts training of the applicant as soon as possible for the above procedure. The sufficient time is more than 3 months is required for completion of such training. This is the first undertaking they have given, more than 3 months, but it is a vague outer limit, my lord. It may be within 3 months because I am given understand that at least it will take 1 month for completion. No. Mandatory 3 months training is there much in Gopabandhu Academy. After the completion of the training, they will appear in an examination conducted by the board of review. If they pass out, then only eligible. Not that inner or outer limit. The second undertaking is very important. Further, as per resolution number 8890 dated 15/3/24 of government in GA and PG, as per Annexure G by 1, a separate recruitment rules for district ministerial cadre of labor department is required to regulate the promotional avenue. So another set of rule is going to come, which will govern the promotional avenue of the present petitioner. In view of that, my lord, the present practice which is going on by directing the collector to hold DPC may be redundant. That is why I have filed a very short reply, and I would pray your lordship to dispose of all these contempt application, considering the undertaking given by the contemptors in their compliance affidavit. And if there is any further grievance, your lordship may kindly grant liberty to the petitioner to approach the authority. So, in response to the second compliance affidavit, I file a very brief reply. It may be taken on record.
Not required. We'll just dispose it on.
Because I have raised such ground, my lord. The clear stand have been taken by the contemptors.
We will give you liberty.
My lord. And some of the collectors, they are saying that we are not authorized to hold DPC. And ironically, the contempt number 1, who is Mr. Sri Amrit Ritiraj, is currently the collector of Kandhamal district. A letter has come from that district saying that the collectors are not competent to hold DPC. Now, in the stand taken by in the second compliance affidavit, the contemptor has come up with saying that another set of rules, each department is going to come. And there is no question of any common gradation list. So, para 12, lordship
will give you liberty.
My lord.
Two compliance affidavits have been filed in the present batch of cases. Stop. The petitioners have alleged of this court's order dated 29/8/2023, passed in WPC number 8649 of 2023, whereby the opposite parties in the petition were directed to upgrade the gradation list by following prescribed procedure within a period of 4 months from production of copy of the order. Stop. It is not in dispute that there has been delay in compliance of the order. First off, however, in the latest compliance affidavit filed on behalf of the contemners, following statement has been made in paragraph 12. Only paragraph 12.
Paragraph 12.
In paragraph 12, which reads thus. First off, next. Learned counsel appearing on behalf of the petitioners has argued that in view of the undertaking so given on behalf of the contemners, comma, he shall not press the contempt applications but the petitioners may be given liberty to question the decisions taken pursuant to the undertaking so given by the contemners.
Whether it is beneficial for us.
If occasion arises, my friend says, if occasion arises, adverse order, they may come.
Comma, if such occasion arises. So stop. Considering the undertaking given and the submissions advanced on behalf of the parties, these contempt applications are disposed of with an observation that if situation so warrants, the petitioners shall be at liberty to raise their grievances before appropriate forum/authority in accordance with as permissible under law.
May I request your lordship, do not want to press the contempt application. The lordship may that in view of the undertaking given by the contemptor, we dispose of the contempt application. That would be.
In view of the undertaking, because we are not inclined to proceed in the present contempt matter further, as we are of the view that there has been substantial compliance of this court's order.
Five batch of five contempt.
19, I recently just got the instruction that the empowered committee who had set on 23rd of this month. Now the matter has been deferred. It shall be taken. Decision shall be taken in the next meeting. Lords may grant me some time, Lord, because there is a direction.
Where is the order?
No, sir. Order is at place.
19 Ashutosh construction.
Lords, page 14, Lords. Page 15, paragraph 5. As agreed by the council, but the parties and after going through the records, this court without expressing an opinion on the merits of the case.
So why have you not disposed of the representation?
Yes. No, representation is claimed some benefits. So we are examining whether he is entitled to that benefit or not as per the law. If he is entitled, we pay it. That is why it has been deferred by the empowered committee. Placed before the empowered committee. So simply dispose.
No, if he's entitled, you can pass an order and thereafter pay.
Yes, Lord. That decision has to be taken. The meeting was held on 23rd of August, Lords, because committee consists of 5 members. They said that some more discussion required. So sometime, Your Lordship, it will be done.
Not more than a week.
Two weeks also. No, 2 weeks we will do it, Lord. Definitely do it, Lord. Lordship, we are pleased to grant 2 weeks earlier. So 2 weeks will do
report
it.
is of the prima facie view. We are of the prima facie view that this court's order dated 14/7/2023 has been violated in as much as the petitioner's representation has not been disposed of even after lapse of a year, without any valid justification. So stop, list this matter on 2 weeks. If in the meanwhile, this court's order is fully not complied with, we will consider initiation of contempt proceeding against the contemners.
Item number 20. Yes, in item number 20, so far as petitioner 1 is concerned, he has been extended the benefit along with another whose contempt has been disposed of. Now, 2, 3, 4 shall be given this same benefit. So sometime, because we have already extended, we'll give 1, 2, 3, and 4 will be given. So Lordship may grant some time that benefit can also be extended.
Went to the Supreme Court, then lost there. That Lordship only in respect of petitioner number 1, they have implemented. 2, 3, 4, they are yet to be implemented. So when my friend is requesting for 1 week time.
Not 1, I've never said 1 week.
Then some. No, you have to implement that order.
Yes.
Otherwise, your Lordship kindly see. Order was passed in the year 2020.
Don't want compliance. He's saying he'll comply, needs some time.
Order was passed when?
My lord, that is 9/12/2020. This honorable court
And
passed
when
the
was
order. Only 2 months time was given. Then
when was the SLP dismissed?
SLP dismissed, your Lordship, Annexure 3, I have, that is on 22/5/2024.
So up to 25 to 2024, there was no contempt.
My lord, your Lordship,
Because they were pursuing.
My lord.
All right. Learned AGA representing the contemners has submitted that this court's order, of which has been alleged in the present contempt application, has been complied with so far as the same relates to petition number 1.
Number 1, my lord.
So stop, this fact is not disputed by learned counsel representing the petitioner. It has been submitted that in respect of response petitioners number 2, 3, and 4 also,
my lord,
the order shall be complied with within a reasonable period. I'll place this matter on 2 weeks.
3 weeks time.
3 weeks.
For orders item 21.
This IA is for correction of the typographical error. Order number 10 dated 14/8/24, my lords. Para 2, instead of writ petition, it is written writ appeal. Only that.
There is a typographical error in the order dated 14/8/2024, wherein, in paragraph 2, the writ appeal has been typed, quote unquote, writ appeal has been typed in place of, quote unquote, writ petition. So from the said order shall be read accordingly.
Item 22.
22, my lord, the requisites were filed late. That may be accepted and notice may be issued.
What have you done?
The notice was issued on the last date. But however, the requisites could not be filed on time. It was filed late. So the office note has been given that due to late filing of requisites, notice could not be issued.
Yeah, Mr. Saswat Das, learned additional government advocate, submits that the requisites have already been filed, but since they have already been filed, hence office registry is directed to issue notice as per order dated. When was the order passed?
The order was passed on 9/7/24.
9/7/24. Fixing it returnable date, had it been done 9/7/2044. List the case after 4 weeks. No, list the case after 6 weeks. What did it?
8/10.
8/10.
8th October. Item number 23.
My lord, on behalf of GP Samal, respondent number 1, he is suffering from severe fever, my lord.
But it's a condemnation or delay. What is the delay?
My lord,
How much delay?
300 odd, my lord. Your lordship has heard this matter. On last occasion, your lordship has asked my learned friend who was appearing for a respondent that only point for consideration in this case that granting of RACP. That she has completed 30 years, but Honorable Single Judge has directed to give them RACP from a particular date. By that date, he has not completed 30 years. So your lordship has directed him to take instruction.
my lord, sir is absent. Adjourned to 1 week, my lord. Adjourned to 1 week, my lord.
Why?
Sir absent due to severe fever.
As requested on your plea.
GP Samal.
You stated that Mr. GP Samal and counsel for the appellant is on for the response. Stop. A week's adjournment is being sought. Does this matter on?
Has been fixed to next week. This can be.
That was the employee regulation matter. You also had this matter last
The
week
number of
also.
employees, that case?
Yes.
Another one. So you appeared for everybody?
Not for everybody. Because the notice was issued through the engineering chief office. Those have received the notices. They approached me and I have already filed.
There are how many thousand?
945. And within out of 945, more than 250 has been irregularity during pendency of the case. Also, in the meantime, have died.
Matter along with
WA is perhaps coming tomorrow, 4/32 of 2021. WA.
29.
29.
Yes.
Coming on 29.
yes.
Okay.
Item 25.
Notice was issued. Nobody has entered appearance.
No, neither AD nor unserved notice is back.
Is issued to R1. Nobody has entered appearance.
Neither no. Note of the registry indicates that neither AD nor unserved notice is back. Is the case on 2024. In the meanwhile, list the case on 2/9/2024. In the meanwhile, registry is directed to download the postal tracking report and place it in the file.
Item 26.
26.
So previous to also in the IA.
26.
26. Notice made sufficient, but nobody has entered appearance.
What is the delay?
The delay of 421 days.
Nobody has entered. There is somebody appearing. Mr. Swine, Siddhartha Swine. Name appears. No? There. One, let us see last week what happened.
What is the point involved?
Point involved, my lord, here direct regularization of service, and that too the writ petition was disposed of at the stage of admission, and without there being any finding that there is a sanctioned vacant post against which the petitioner has continued for a considerable period. The
Admission.
In last date he was there. Actually, he had asked for time. File an objection.
Not right.
Because they are similar matters, I think.
Yes.
Similar matters, engineer in chief. So if you tell me which date is posted, then. Doesn't detail much.
400.
Oh, 400. Then this is another case. Sorry. Can you tell us if any connected case is there? We'll post it to that date.
I'll verify. Yes, my lord.
Kilometers are there.
There, my lord.
Can give us one date. One appeals for the respondent when the matter is filed. Is the case tomorrow.
Item 27.
Please, my lord. Please, my lord.
137 of 2022. That's
All right.
similar.
Tomorrow we'll. Put a log it to sleep. Continue on. 137 of
2022.
please check. 22 or 23?
2022.
Okay.
My lord, before taking this matter, the last order passed on 18/7/2023. That is available in the rejoinder, page 24.
Yes.
My lord, can I read that?
What?
We have heard the last order on 18/7/2023. That was available in the rejoinder, page 24.
Which order you are?
18/7/2023. Last order.
We are appearing in item 27.
27.
Last order is 12/8/2023.
No. 18/7/23. 18/7/23.
That is not the last order. That is not the last order.
This order,
First order of the last order.
may I read out that order?
No, we are looking for the order. Wait.
Yes.
18/7.
Justice Talapatra and my lord, madam.
Yes, 18/7.
Hmm.
Third order. It's not
Sir.
the last order.
We have heard Mr. Pondal on counsel appearing for the appellant at length. Mr. Pondal on counsel has pointed out that the respondents had agreed to shift the storage and pump house to the plot number 440 from the plot number 497. It appears from the para 5 that the said plan of shifting was agreed by the government officers who were having discussion with the villagers, including the petitioner. Mr. D.K. Mahantil, on an additional government advocate, has submitted that he can make any submission offhand. He is to take instruction about the status of the project.
Yes.
My lord, so far the order is concerned, my lord, that
Next order dated 29/11/2023.
yes.
None appears for the appellant at the time of call.
Well,
The appeal stands dismissed for want of prosecution. Thereafter restored or what? On 29/11/2023, the writ appeal has been dismissed.
that is in this. Sorry, I don't have instruction. Let this matter be taken up next week. I will also take.
No, must have been restored. That is what I'm saying. Restore ହେଇଛି?
No, it has been restored. In CMAPL also 870 of 24.
So what do you want?
My lord, basing on the order passed by the Honorable Single Judge, that was, my lord, that was, I have quoted the order
Same approach direction to IAS.
on 2021. I have quoted that order in my writ appeal, page 3, sir. Regarding hard to the fact and submission and the nature of the relief sought for, that without going into the merits of the case, the writ petition is disposed of and directing the Assistant Executive Engineer RWS&S Nimapada, opposite party number 5, to dispose of the representation of the petitioner, Vide Annexure 5 series, within a period of 3 months from the
date of receipt of the certified copy of this order. B. Passing a rigid order, taking into the consideration of the plight to be suffered by the petitioners. The petitioners are directed to supply the copy of the writ petition containing all the annexes to the opposite party number 5 along with a certified copy of this order for convenience and the reference to Annexure 5 series. Again, till disposal of the representation, parties shall maintain status quo as on date over the spot in question. With aforesaid observation, the writ petition is disposed of. Since since the opposite party violated the same order, passed in WPC number 2408 of 21, a contempt proceeding has been initiated by 7138 of 21. The said contempt petition, so cause affidavit also filed on 16 December 2021, and in that contempt petition, that in reply to the averment made in para 4 of the contempt petition, it is humbly submitted that the deponent never violated the order passed by the Honorable High Court in any manner. Moreover, status quo has been mentioned over the plot in question since 22/9/2001 had no further work related to the pipe water supply to the Dhamantira has been taken off over the plot in question under the legal process after received the order dated 29/9.
Mr. Why are you reading all that?
Because these are the relevant orders, sir. These are all relevant orders. Thereafter, the contempt proceeding, they have agreed for a compromise, but the compromise, basing on the compromise, the state officers, they have also agreed for shifting the ECR from 497 to 440.
Are you challenging an order?
Sir, the order passed by the Honorable Single Judge is under challenging writ appeal.
So how is that order illegal?
Because, sir, this is the order when they have agreed for compromise. Basing on compromise, contempt proceeding also dropped. That has been quoted here. Contempt proceeding has been dropped. For another more chance also given to the alleged contemptor by Honorable Justice Sinha, that saying that you to comply the order, that don't proceed with any work so far the plot number 497 is concerned. But they have flouted that order. Despite the repeated order. Despite the repeated, for that reason, the Honorable Coordinated Bench, Division Bench, also sought for an instruction from the advocate that whether you have flouted the order, was there any that construction is the over for plot number 497, which is clearly violation of that agreement. Basing on the agreement, contempt also dropped and nothing was remained. But thereafter, they are going on constructing over the plot number 497, which will create clear obstruction.
I have not been able to understand. See, you have not addressed us on the issue.
Sir.
You are challenging an order.
Yes.
What was the basic fact? Basic.
They have constructed a ECR, that is elevated storage reservoir, over the plot number 497.
That after,
sir, because of that construction, that has created obstruction to for me to enter into my cultivable land. For that reason, we have also approached them, but they didn't listen. I came to this Honorable Court. Honorable Court, that order I have read. This Honorable Court in the year 2021 passed an order for disposal of the representation. Till then, the status quo over the land to continue. But they, despite that order, they have flouted the order.
Flouting is an illegality. You are come to paragraph 11.
11, yes. Then we file a contempt petition. When the contempt petition is pending, they said, no, we are not violated the court's order. We are ready for compromise. The petitioner as well as the officers, they arrived together and there was a compromise. And the terms of compromise is also quoted here. Metro, my lordship,
your terms of compromise will not bind the court. The court's order come to paragraph 11.
Sir.
How is this incorrect?
Yes. That shifting of para 11, sir. Shifting of the construction to plot number 440, 20 meters away was only a request on behalf of the petitioner. However, the construction are being made as per the settlement made before the parties. before the PRI member. Hence, this court is of the considered opinion that no deviation has been made by the opposite party number 5 in the said settlement. It also appears that due to construction, the ingress egress to the agricultural land of the petitioner is not affected, which was also the grievance of the petitioner at the outset. Further shifting of the bore well does not arise as prayed for in the writ petition, as it has already been sunk by the time the earlier writ petition was filed. Shifting the bore well was never agreed upon by the parties to the aforesaid settlement. But my lord, may I draw my lordship the settlement?
And for ingress and egress, how can you afford you could file suit?
That, my lord, earlier there was an order passed by this honorable court that the status quo over the land to be continued.
Status quo for the land, now the land single judge has decided it, and in very clear terms.
No, that goes against the terms of the compromise.
The court is not bound by your terms of compromise.
No,
the court is bound by law.
Sir, in contempt proceeding, when there was a contempt proceeding, they have agreed that they are not encroaching the land of 497.
Sorry, sir. Sorry. The present intra-court appeal has been filed, putting to challenge an order dated 7/4/2023 passed in WPC number 23500 of 2022. Stop. The petitioner had the said writ application seeking a direction to the opposite parties to sift boring. What is that boring?
Boring well, boring point, what?
Yes, sir. Elevated storage reservoir.
Elevated storage reservoir.
And it will be, and it's a government land.
Only shifting 25 meters away from the 497 to 4.
What is that? EE?
ESR.
Elevated storage reservoir.
Storage reservoir from its original point in plot number 497.
Yes, plot number 497.
97 to 440.
To 440, which is 25 meters away from
the main point.
In Moja, Dhamantira, in terms of the compliance report dated 8/12/2021, filed in contempt number 7138 of 2021. Contempt proceeding was submitted.
Yes. Basing on that compromise.
Stop. Mr. By the impugned order, London single judge has held that the earlier decision to shifting of the construction to plot number 440 was only on the petitioner's request. Stop. The constructions were made as per the settlement made before the parties. Before what is PRI?
That's Panchayat, some of the members must.
No, public representative.
Of the locality must.
Representatives.
PRI members. So pata kar lena kya aapko. Stop. The court reached a conclusion that no deviation had been made as assured by the respondent number 5 here.
Yes.
Respondent number 5 bracketed opposite party number 5 in the writ application, in the said settlement. Stop. And single judge further held that due to the construction, comma, the ingress and egress of the agricultural land of the petitioner was not affected, comma, which was the petitioner's original grievance. So stop. In such view of the matter, and single judge further has further recorded that shifting of borewell was never agreed on the parties to the settlement, and accordingly, the petitioner's request, petitioner's prayer to shift the boring from original point to 25 meters away over plot number 440 was not sustainable. So stop. Next. Learned counsel appearing on behalf of the petitioner has submitted that in the contempt proceeding, what is CONT?
7138 of 21.
7138
of 21.
21. A settlement was arrived at between the parties to the following effect. कोट कर दोगे तो पैराग्राफ 8 में कोट किया हुआ है. Stop. It is evident from the records that the a specific stand was taken in the writ proceeding on behalf of the estate / respondents that it was accepted by the parties in front of local Panchayat Raj institution bracketed PRI members. Compound wall would be constructed 15 meters away from the last embankment of the petitioner's appellant's private plots number 501, 502, 503 and 496 in Khata number 206/81 and 206/80. First off, the boring point had already been constructed over the government plot number 497 on 16/9/2021 itself. First off, it was also stated in the counter affidavit. It was also a stand was also taken on behalf of the estate respondents that the transformer for water supply will be inside the government plot number 440, and thus there would be no difficulty for the petitioner to approach his agricultural field. Next, learned counsel appearing on behalf of Mr. Mahapatra, learned counsel appearing on behalf of,
Ponda.
Mr. Ponda, learned counsel appearing on behalf of the appellant has vehemently argued that the finding recorded by the learned single judge to the effect that the decision of the that the action of the respondents was not in contravention of the settlement arrived at between the parties is an error apparent on record. So he accordingly submits that he submits that learned single judge ought to have given due weightage to the settlement between the appellant and the state in the
State
matter
officers.
of
State officers.
state officers in the matter of shifting of ESR care to plot number 440. Stop. Next, we have reduced the impugned order passed by the learned single judge, as well as the materials on record. We have considered the submission advanced on behalf of the appellant. Stop. Learned AGA. Next. Learned AGA appearing on behalf of the respondent has argued that the petitioner's grievance was in relation to construction of elevated storage reservoir pump house PWS bracketed piped water supply to Dhamantira over plot number 497. Stop. He has submitted that there has been no violation of the settlement arrived at between the parties, as there was no deviation, as there has been no deviation from the assurance given by respondent number 5 in the said settlement. And accordingly, the finding recorded by the learned single judge in the impugned order suffers from no legal infirmity requiring this court's interference. Stop. Next, it is apparent from the materials on record and the submissions advanced on behalf of the appellant that the petitioner's grievance against construction of elevated storage reservoir pump house over plot number 497, which is a government plot, was mainly on the ground that such construction would affect ingress and egress of the appellant to and from his agricultural field. Stop. After having duly considered the pleadings on record, learned single judge has come to a definite conclusion. Learned single judge came to a definite conclusion that there was no probability of any hindrance to the appellants to access his agricultural land. Stop. Then counsel appearing on behalf of the appellant has submitted that the compound wall ought to have been constructed 50 meters away, 25 meters away as was assured. So stop. We do not find any such assurance given to the petitioner by the respondent number 5 that the said wall, the compound wall, should be constructed 50 meters away from the central point.
Main point.
From the, what is that called? That point is called main point. Oh, stop. Next. We do not find, next, considering the fact that the findings of a single judge are based on due appreciation of the materials available on record of the writ proceeding, we are not inclined to interfere with the same, with the impugn order. Stop. We do not find any merit in the this appeal, which is accordingly dismissed.
Item 28.
28, my lord, 2 days delay there is.
2 days delay. We are
Well, 2 days. I am for the respondent 3A and 4. I am for respondent 3A and 4.
So delay we are condoning.
But it is more than 2 days.
Huh?
It is more than 2 days.
No, official. Or like 10 days, 20, 10 times. Yes, let us come on merits. So this is not come for confirmation or delay only. It's come for admission.
Yeah, order soon.
Order. So item 29.
28 minutes for orders.
8. 1, 4, 6. Delay of 2 days has been shown by the stamp reporter.
Yes, ma'am.
Is there any mistake in that? Don't think. IA 3787 of 2023. This IA has been filed for condemnation of delay of 2 days in filing the writ appeal. Considering the period of delay, we are inclined to allow this application and condone the delay in filing the writ appeal. The IA is accordingly allowed. Fresh admission allowed and disposed of. List this case for fresh admission on 9/9/2024.
Item 29.
Do you have you received a copy of the writ appeal? You have?
I am for opposite party 3A and 4.
Also received.
You are Mr. B.K. Naik.
You can
Already.
We can receive. Receive one. Yes. You receive notice for the appeal also?
I have issued notice only on the delay notice.
All right.
But
you can receive notice.
Yes.
Mr. Acha, Mr. B.K. Naik, learned counsel, receives notice on behalf of the appellant. When do we
3A and 4.
Of the respondents 3A and 4?
Again.
How many other respondents? Who all are there?
There is another respondent 5 now.
Oh, okay.
Also, take up for admission if nobody have been Notice will be issued, then no, notified.
All right.
Item 29.
29, there is a delay of 21 days. That has entered appearance for respondent one.
Respondent one will.
Delay of?
21 days will.
Yes, you are Mr. Pradhan or Mr. Sethi?
Mr. Sethi.
Mr. Sethi.
Item 30.
Just one moment.
Appeal
Who's
memo
respondent to in item 29? Who's respondent to? Item delivered.
For my respondent, it is the principal,
Okay.
the trust fund.
Though good line though notice is sufficient on respondent number 2. Nobody has appeared on behalf of respondent number 2. This IA has been filed for condoning 21 days delay in filing the writ appeal. Though notice is sufficient on respondent number 2, nobody has appeared on his behalf. Mr. Gopinath Sethi, learned counsel, has appeared on behalf of the respondent number 1. Considering the period of delay, we are we are inclined to allow the inclined to condone the delay in filing the IA is accordingly allowed and disposed of. Have you received a copy of the written?
No, appeal memo not received.
Appeal memo, I'll serve.
Mr. Saswat Das, learned additional government advocate, undertakes to serve a copy of the appeal memo on learned counsel appearing on behalf of respondent number 1 by
tomorrow.
By tomorrow. This is the case for fresh admission on 2/9/2024.
Item 30.
30, well, there is a delay of 189 days. This has been issued. Notice on the question of limitation issued on 15/7/24.
Wait. Item. Postal tracking report indicates notice has been served on the respondent, sole respondent.
My lord.
On the sole respondent number 1 on 3/8/2024. None appears for the respondent number 1 when the matter is called. In the interest of justice, list the case on 9/9/2024. In the meanwhile, registry is directed to ascertain if any counsel has appeared on behalf of the respondent number 1.
31.
How many days delay?
290.
Leadership 290 days delay. Leadership, according to the contentions versed in the interlocutory application, on 13/3, the order was passed. Subsequently, on 7/12/2023, the Department of School and Mass Education are versing a letter to Department of Odisha Elementary Education that we have perused the order and subsequently we want to file an appeal. Now, after that, on 26/12/2023, Department of Odisha Elementary Education write an application to the Advocate General's office, and on 17/1/2023, the appeal has been filed. Ladyship, the interlocutory application has been filed under Section 5 of the Limitation Act. Ladyship, so sufficient cause must be there to condone the delay.
Ladyship only?
Sincere apologies, Lordship. Sincere apologies. As the question was raised by Ladyship, so I went on with the
all right. No issue.
sincere apologies. So, Malash, there isn't any sufficient cause, as an offspring of which we do not find any or through which the delay should be condoned. This is our submission, sir.
What is the point?
Lordship, we haven't received the writ appeals copy. We haven't received the writ appeals
What
copy.
is the point involved?
The point, my lord, this is a case, my lord, this man was, respondent was terminated in compliance to direction of this honorable court in another writ petition. Subsequently, in another selection process, he was engaged. And pursuant to politician, he was also regularized. But the honorable single judge has quashed the termination order on the ground given a notice. That is the small point here, madam.
But isn't that correct?
Hello?
Because you are saying that he has been appointed on a second selection.
No, in second selection, we have not terminated. In second selection, he was appointed and he was regularized.
That first thing.
First selection that was challenged in a different original applications before the honorable tribunal. Tribunal directed to prepare a fresh select list, and those will not name found place in that select list, they will be terminated. That was challenged before my lords. And your lordship also confirmed, saying that those name who will not find place in that select list, reselect list, they will be terminated. In compliance to that direction, he was terminated. So one observation in that, my lord's order, if the state government may give them an opportunity of being heard, taking into account that our stand is that.
So there was an observation that they should be given opportunity of it.
May, the state government may.
May, yes.
Yes.
May means.
So taking into account that aspect, but it is an admitted fact in compliance to the direction of the select, and that select list, his name did not find place. This is the fact, madam.
If the honorable court permits, a writ appeals copy may be served to us, and subsequently lordship may adjudicate both means interlocutory application and then go on. Grateful.
I relate to the question of condonation of delay shall be considered at the time of admission. Full stop. A copy of the writ appeal is served on. You are Mr.
Saurabh Das. I have power leads.
Yeah, and Mr. Saurabh Das, learned counsel, appearing on behalf of the respondent. Sole respondent. Kuntia.
Yes, ma'am.
On the sole respondent. This is the case on 9/9/2024.
Yes, my lord, headmaster is a former party, respondent number 1.
Okay, counsel appearing on behalf of respondent number 1. Both the heading. Yes. We make it 10. No, I was putting 9. 2 Mondays having holidays. So maybe few matters will be there. That is right.
Item 32.
I'm serving copies of.
Leadership objection. My lord's objection to IA has also been served.
We'll hear both.
No, for the sake of records, I just submitted.
There
32.
objection at to IA at flag Y. It's there on record.
Great.
Instead of writing, shall be served in court.
32.
32, my lord, there is a delay of 242 days. The last order, 4/7/24.
Yes.
But nobody has entered appearance.
Tracking. No, there are 2 respondents. Are both contesting parties, R1 and R2?
Yes, madam.
Both.
Both are.
Okay. Postal tracking report indicates notice of limitation. Notice of limitation had been bagged. Postal tracking indicates that notice of limitation has not yet been served on the respondents 1 and 2, and dismissed the case on 17/9/2024. In the meanwhile, the registry is shall 79 or 99? 99, I'll list the case on 9/9/2024. In the meanwhile, the registry is directed to upload the latest postal tracking report and place it in the file.
Item 33.
In item 33, my lord, notice has been issued on the question of limitation. None has appeared to me.
Let's see which date it has been delivered. Item 33.
Notice was issued on 26/6/2024.
delivered on 10/7. Okay. Postal tracking report indicates that notice has been served on respondent number 1 on 10/7/2024. Full stop. None appears on behalf of the respondent number 1 when the matter is called. In the interest of justice, list the case on 9/9/2024. Please write it in the IE.
Item 34.
Just on 9/9, registry is to direct you to verify if any counsel has appeared on behalf of the respondent number 1. Yes.
Item 34.
Please, madam. Order under challenges at page 34. My lord, the order was passed without hearing us. There's a 19 days delay here. And this was, my lords, basing on a batch of other cases, 2 other writ petitions, my lords, which my lords, were again disposed of on basing on some other.
Of continuation or delay?
My lords, 19 days delay.
Is there any merit in your opinion?
My lords, these are all self-sustaining courses. The Honorable Single Judge is directed to regularize them. There is no regular posts. They were all on a constitutional lordship, but for a second, come to the, my lords, the appointment letter, initial appointment.
All right.
They're all on a consolidated, on a self-sustaining program. If there are students, that course will be held. If not, on that semester, that course will be given a go-by. So therefore, on that manner, there is no
counsel. Along with there with you, Mr. Palit.
My lords, Mr. Amitabh Das, Amitabh Mishra.
Mr. Amitabh Mishra, learned counsel. Issue notice. Issue notice in the writ appeal as well as in the IA for continuation, as well as in the interim application filed for continuation delay of how many days?
19 days.
19 days. Returnable within 4 weeks.
Can serve it.
Registered post / speed post with AD, returnable within 4 weeks. Requisites for which shall be filed within 3 working days. 6 weeks?
8.
Great.
Item 35.
So, Mr. Parley, there is only one respondent. Sole
No,
respondent.
there are 2 others at pro forma, state government and BPUT.
Okay. You should notice that R1. Then
R1, I can serve copy on Mr. Rautrai's office also. I may be permitted to serve copies, they were appearing.
On R2 and 3.
No, R1. R1.
No, how can you serve unless he appears? How can you serve copy? If there is appearance.
He was appearing before the single judge.
We could have served also before order was
He is not bound to appear.
No,
It all depends whether the client gives him authority power.
No, I'm asking about the other respondent.
Other respondents, I can
Serve copy.
BPUT, I can serve on Mr. Tushar Satpathy. And state mallards, I can serve on my learned friends.
Then Mr. TK Satpathy.
Tushar sir.
He is Mr. TK Satpathy.
TK Satpathy.
Respondent number 3.
Tushar
Kanti Satpathy. R3. R2 is to the state.
Okay. Next,
Item 35.
May I please, Lord, in the item 35, there are some fresh cases are listed before the Lordship. Today I instructed to appear in a writ appeal number 260 and 370, 395, 396, 405, 502, 535, 601, and 602. Your Lordship, I appeared today. Your Lordship directed my non-senior to serve me a copy of the IA. So I filed the objection and put up your Lordship fix a date for hearing the limitation petition.
So what is the delay?
Today I am appearing, today I am appearing in some cases.
In first case, your Lordship said that item 35. In first case, 120 days delay. That in second sub-item, your lordship have already condoned the delay. That is, my lord, WA 170 of 2024. Similarly, in WA 232 of 2024, your lordship all condoned the delay. In WA 260 of 2024, there is a delay of 114 days. In WA.
So what do you want, Mr.?
Yes, I appeal today, my lord. Those.
So we can pose these matters for admission.
But unless, my lord, I file objection,
We'll give
No,
you.
you say if you don't file, others you have condemned the delay with filing objection, not filing objection.
When I file the objection. No.
Admission, even if the matters are placed for admission, that will not disentitle you from filing your.
In some cases, my lord, the notice not issued, my lord, till today. Some fresh cases.
Some of the cases.
Yes, some of fresh cases not issued. Today, there is a.
Notices have not been issued, then can we pass any order in the absence of party? Even if the cases are listed for admission, without issuance of notices, we shall not.
In these cases, on these cases, I filed the objection, my lord. If 4 cases are now pending, I filed the objection. That 4 cases, your lordship condone the delay. I have no objection. I file also objection. Your lordship condone the delay and tag with the item second case, my lord. That is 1242. And other cases today appearing, and some cases are I am not instruction issued to me for appearance. Issue notice for their appearance. Thereafter, also fix a date. You also hear the matter. I have no.
Waiving notice, you are appealing.
Yes, my lord.
This. Give a list you have dictated, but we could not write down because.
These
number
260. I will give the number to today as appearing. 260, 370.
All right. When will you file your objection?
2 weeks time.
2 weeks time.
Well, other cases also.
No. We understand that. Therefore, we wanted that let all these matters be placed for admission. The action of condonation of delay shall be considered at the time of admission. And that the delay cannot be condoned without issuance of notices.
Yes, well, for that reason, I have your lordship have stated that some cases have now appeared, and some cases also not in instruction not issued to me for appearance, but the notice may be issued.
All right, then we can do one thing. In such cases where the part either delay has been condoned or you have appeared, we can set those cases apart. And in other cases, we can issue notice.
Yes, madam. The objection. In that 4 cases, you will also condone the delay. That is one.
What are those cases in which you are appearing?
My lord?
What are those cases in which you are appearing?
In WA number 260, 24.
WA number?
260, 260.
Yes.
Then 370.
Yes.
395.
Yes.
396.
Yes.
405. 502. 535.
Yes.
601. And 602. 9 cases, my lord.
You file your vakalatnama there?
Yes, ma'am.
All right.
Yes.
Mr. So-and-so, Appellate Counsel states that he has instructions to appear on behalf of the private respondents.
Yes.
In WA number 260/24, 370, 395, 396, 405, 502, 335, 601, 62. Also, he submits that he shall be filing wakalatnama in the registry and objections to the limitation petitions. Shall be filing wakalatnama and objections to the limitation petitions in the registry within 1 week.
2 weeks, ma'am.
Within 2 weeks.
There are some retired from.
Within 2 weeks. Post op. Issue notice rest of the matters.
No, well, in some matters
other than
Other minor.
In other cases, he has appeared and notice has been issued, delay has been condoned in some cases. That
Two cases.
They tell us in which nobody has appeared and notice has
Yes,
been issued.
Confused Lord, mark that in 312, that in that case he has appeared. First case. In second case, W170/2024, he has appeared and delay has been condoned. In W222, he has appeared, delay condoned. Then in W260, notice, then W264, notice it to go, my lord.
264.
My lord. And W313, notice has been issued on the question of limitation. 314, notice has been issued. And 315, notice has been issued. And W353 of 2022-24, no notice has been issued.
355.
53, my lord. And 358.
This may be issued.
Then my I am not submitting those numbers he has given. So only then 397 of 2024 and 399 of 2024, 485 of 2024, 501 he has given that. 501 of 2024 and 509 of 2024, 535 of 2024 and 603 of 2024. In case to go.
In another case that is
I would have noticed.
Then I would notice in 353 notice. 358 notice
WA 264. 353, 358, 397, 399, 485, 501, 509, 535, 603. Issue notice to the respondents. One respondent.
Hello.
Yes. The respondent. I or WA. Both. Negotiation. In 312, we can condone the delay.
in
120 days delay.
312. 312, I filed the objection. You will also condone the delay.
Condone.
Yes.
We have condoned.
Yes.
It has not been condoned.
It has not been condoned.
So we can condone because we have condoned the delay in other case. Therefore, we can condone here.
Yes.
I number so and 312 of so. You have filed objection.
Yes.
This application has been filed for condonation of delay of 312 days in filing this appeal. Stop. And counsel for the respondent has the contesting respondent has entered appearance through Wakalatnama. Stop. An objection has been made to the application seeking condonation of delay. Stop. As in the analogous matter, that is WA 170/20 matters and WA 240 of 24. We have condoned the delay, comma. We have condoned the delay, comma, we consider just and proper in the interest of justice to condone the delay. In this case also. Stop. Yes. And 2 and 312. Yeah. Yes.
And 313 alerts can come on the delay.
313.
Up to
Notice.
2020. Look, here appears.
I am appear.
Same order
313
same
and
order
314, 315. I am appear and file the objection.
313, 314, 315,
Right.
same order.
And
No, 264 and notice jibo. The notice we issued 264.
And 371 of 2024 and 500 of 2024. In all these cases, here the appears that
371 and
500 of 2024.
5.
00, madam. 500.
He has appeared.
Yes,
Right.
ma'am.
Same order. Yes.
In 264, notice we issued, my lord.
264 notice, 264, 33, 358 and others notices have been issued.
Well.
And before the order is signed, you will have to go through and both of you will have to certify that the order is correct.
The case numbers.
Yes. In all the cases, my learned
This
friend
matter
need to
on
appear.
6 weeks.
Item 36.
36, my lord. There is a delay of 55 days. There is a delay of 55 days. Respondent has entered appearance.
Yes, condone.
Let me condone the delay. But so far the merit case is concerned, the petitioner terminated since 2016. And stigmatic termination without following the principle of natural justice, the honorable single judge passed a rigid orders, around 50-60 pages orders. So far my submission is concerned, there is no merit in the readable orders. So only because 16 the petitioner is out of service. So let's not take up the matter on merits. This is my limited submission.
Yes.
Lordship,
16 days delay.
the order granting non-renewal of contract and termination, there is a difference, my lord. Had it been a case.
No, where is the order of the learned single judge? Let us see the order.
The order of the learned single judge, that is at.
So let it come for admission, Mr.
Yes.
Let's fix a date.
We will fix a date.
That will not come.
We will fix a date and you
We are
just
interested
tell us.
to somehow
See,
clear the matters.
the orders of termination, the writ petitions challenging the order of termination from service or dismissal or suspension, these are urgent matters. Such matters should be taken up on urgent
Yes,
basis.
but this is my
So we will
limited.
take up. And the order is already there in your favor.
Yes, madam. And for 2016 is out of service, and now what is the question also can visualize?
Maybe.
Is this a batch case?
No, one man, only one man.
What is this? Oh, this you have given for reference. This is WPC 4978 of 2024. That's a batch case. What is that?
That's no one.
And it's a one
36
series.
36
No, 36 no geta. 967. No, sorry.
365.
365.
That is 365, only one case.
Sorry. 36. I have opened 38. 365. IA account. This IA has been filed for condemnation of delay of 50. So this is 56 days. 56 days in filing the recovery. Considering the grounds taken in the interim application, we are satisfied that this is a fit case in the interest of justice to condone the delay in filing the appeal. The IA is accordingly allowed and disposed of. Have you received a copy of the appeal memo?
No.
Disposed of. Writ appeal copy of the appeal memo be served on Mr. Dilip Kumar Mahapatra, learned counsel, appearing on behalf of the respondent, the sole respondent or
Sole
the
respondent.
sole
The sole
respondent by tomorrow?
By tomorrow.
By tomorrow, list the case for admission on 9/9/2024.
What's the fixed at 2 p.m.
2 p.m. Notice of admission.
Otherwise,
Oh, Mr. Dilip Kumar Mahapatra, learned counsel, accepts notice on the issue writ appeal kar diyandu. Issue notice. Mr. Dilip Kumar Mahapatra, learned counsel, accepts notice on behalf of the respondent. List the case for admission on 9/9/2024. On that day it doesn't reach, then you mentioned we'll fix up a date at 2 p.m. Already. A copy of the appeal member, I got day after tomorrow. Within by tomorrow. By tomorrow they do it.
Yes. Item 37.
37 minutes.
I'm appealing on behalf of 100 minutes.
Kindly.
There was a delay minutes of 376 days delay minutes. I'm making some research minutes. I'm unable to prepare the objection minutes. Your Lordship may kindly call this matter next week so that I'll file my objection on
I
that.
just point out one thing, minutes. I'm not against his delay. Minutes.
No, you are not against his delay.
No,
Delay is by you.
against his objection, minutes. How the matters move. He has relied on a order by the Honorable Single Judge, which has been stayed in writ appeal 1 year ago. Then after 1 year, he comes and shows that order and says that the matter be disposed of in that light. And then the matter was again disposed of. And then thereafter he files a contempt. And thereafter, we come to know, and then we have here. So
on the first
it's in the state. The writ appeal
On
is still
29/7, I think you had appeared because you were appearing for
even in
caveat. Copy has been served.
Yes,
even in that writ appeal, they had appeared on caveat, and it was
Exactly,
stayed.
that's what I'm saying, 1 month back.
It appeared on caveat also. Delay we condone, let matter be heard.
All right, you file your objection.
Yes, madam. On the next.
Mr. Atul Tripathi, learned counsel, appearing on behalf of the respondent, reads for 2 weeks' time. 2 weeks or 10 days? For 10 days' time to file an objection to the IA for condemnation of delay. Full stop. List the case on 9/9/2024. Objection, if any, shall be filed before the next date. Full stop. That dispensing with filing of certified copy, that application is allowed. Right, that as per the.
Great.
Item number 38.
38. There are two matters. Delay of 15 days. The judgment sought to be challenged in both the appeals have already been quashed by this honorable court in appeal preferred by the state and some private respondents. That is, in respect of junior teacher schematic, your lordship have already quashed this judgment.
And your lord,
Because these cases were filed with a 15 days delay, so this could not be taken up along with that batch.
lordship, I am appearing for the respondent in writ appeal number 967 of 2024. In that judgment, the lordship has also observed in para number 65 that it goes without saying that cases of the writ petitioners shall be considered against the leftover vacancies in the terms of the direction as above.
Yes.
My lord, may pass similar orders. I do not have any objection.
Because the judgment has already been quashed, which is under challenge in the present writ. So it has to be disposed of in terms of that judgment.
Yes, ma'am.
Right. How much delay?
15 days, my
Only IA number so and so.
Two matters.
Two matters. Both the matters 15 days.
But first matter, have you appeared?
Yes, my lord. I filed wakalat naam, my lord. On 20 August 2024. Ma'am.
Your Mr.
Swayam Prabhu Jana, my lord.
E. Jenna.
So on behalf of the applicant and also for the respondents. So there is delay of 15 days in fixing the present appeal. So considering the explanation put forth in the application seeking confirmation of delay, the same is allowed. The delay stands controlled. So, and counsel appearing on behalf of the parties do not dispute that this case is squarely covered by the decision rendered in WA number 580, 780, 740, 710 of 2024, bracketed Jaimatri Senapati and other sources, state of Odisha. State of Odisha, whereby the judgment of the single judge, which is under challenge in the present appeal, has been set aside. So, accordingly, the present intra-court appeal is allowed. Stop. When counsel appearing on behalf of the respondent has rightly submitted that the respondent's case may also be considered in the light of the observation made in paragraph 65 of the decision in case of Jaimarti Senapati. Also, these appeals are allowed with these appeals. This appeal is disposed of with the same observation as contained in paragraph 65 of so and so. Separate order, separate order.
Item 39.
In 39, there is a delay of 39 days.
Does this matter?
Matter regarding that rehabilitation assistance scheme, that his case was rejected in 2016. In accordance with the Rule 2B of rehabilitation assistance rules, the Honorable Court has disposed was that order, saying that he is covered by that Morayananda City case. In fact, that judgment is not applicable to the case at hand, because in that Morayananda City case, that old rule, new rule, which is to be applicable, that was the ratio. But in that case, that under the old rule, her case was rejected.
Where is the order?
Let's make on page 54, madam.
So we are issuing notice
On the question of limitation.
Limitation.
38 or 39? IA number 3850/2024. Issue notice on the question of limitation. The registered post stroke post with AB returnable within 6 weeks, comma. Issue notice on the question of limitation. By register on the sole respondent, or how many respondents?
Yes, sole respondent.
On the sole respondent on the question of condemnation of
Two respondents, mother and daughter.
on the respondents on the question of condemnation of delay by registered post with AD returnable within 6 weeks. Requisites for which shall be filed within 3 days. List the case. 8 weeks. 6 weeks and 8 weeks release.
29th October.
29/10/2020.
Item 40.
The respondent.
On the last occasion, my lord has directed to serve the copy of the limitation petition as well as a memo of appeal, my lord. I have served on the same date, my lord. My lord, 158 days of delay, my lord.
How many?
158 days. My lord,
Yes. Why should we not condone?
Lordship may condone the delay and put up the matter to some other day, because this is relating to appointment under rehabilitation assistance scheme. So it may be taken up within 10-15 days. Since 2010, the petitioner.
What is the legality in the order?
my lord, that's my lord. 1 day, my lord, given, my lord. I have not prepared the entire case.
Tomorrow?
Tomorrow.
As a
My lord, maybe next week, my lord.
No, why?
Maybe
See his predicament also.
my lord. Next week.
Day after tomorrow. Day after tomorrow.
My lord.
I will requested on behalf of the appellate, discuss matter on Thursday.
Item 41.
In this case, there is a delay of 99 days, my lord. Filing the appeal, they have filed an objection and served a copy on me before 3 days, my lord. And there is an alias amendment, I have to sought for instruction, my lord. May I pray let
Instruction for?
instruction because they have stated that we are not the employee of the organization because it's quarter eviction of quarter, my lord. So I have to take instruction from the client because I have stated in the affidavit they are working under the.
Is this under company law or what?
No, my lord. It is eviction on quarter from the company's quarter.
This is what we are saying.
May I pray 1 week after, my lord.
Which company?
MCL.
So this is for condonation of delay. We can condone the delay. All right, come after one. If you are not employees, then vacate it.
Madam.
In
my petition, I stated
This the case on 29/2024.
Item 42.
Item 42. I am appearing for respondent. Respondent number 1. The impugned order is 2 parts. So far as the second part is concerned,
Yes.
I am in this DWP, I am appearing for respondent number 1. The impugned orders are 2 parts. I am challenging also file DWP challenging the second part of the order which is pending. That is WA number 2304 of 24. Let it come with that case.
How much delay?
In my case, delay is also there. Both the cases, you also control both the delays for that.
Both of you can
Is it a bill number?
play a friendly match.
2304 of 24.
1000.
304 of 24.
Is the case. Is the case on 2/9/2024 along with the WA number 2304 of 2024. Which, according to according to Dr. Jitendra Kumar Lenka, learned counsel appearing for the respondent, has been by the respondent. Respondent
one.
Respondent appearing for respondent number 1 has been filed by him. Yes, 29.
Item 43.
And file have been filed by the respondent number challenging the same impugned judgment. Yes.
My lord, kindly permit to withdraw.
Withdraw.
Item 44.
May under the date, modify the date of order, my lord. I paid 2024 instead of 18/6/2024.
Which order?
Order that I paid 2024. The order has been passed on that date, but it has been inadvertently mentioned in the order sheet that 18/6/2024. That can be modified.
So what should have been the date of the order?
I paid 2024. But the order sheet it is mentioned in the 18/6/2024.
Just one moment. First read.
There is a typographical error in the first order dated. First order.
And the order dated.
First order in this case.
Disposing of the case.
Wherein first order typographical error in the order disposing of the case in as much as the date of the order has wrongly been typed as 18/6/2024 instead of 5/8/2024. The said order shall be treated to have been passed on shall be read along with the present order and shall be treated to have been passed on 5/8/2024.
Item 45.
But this item was by the order dated 18/6/2024 had directed me to obtain instruction with regard to the notification that's authorizing the sub-regional officer Sadar Kotak to be the collector, that is the authority under section 5 small I of the Orissa State Level. But somehow they have given me a notification wherein all the sub-collectors are there in other accepting Kotak. So if you receive the last one, grant me next.
No further.
Yes.
You have given enough chance. We have given you enough opportunity.
Right, Milos. So we are also granted with 3 opportunities. Now they have found out a notification wherein not accepting the sub-collector Kotak, they have given the names of other districts. I can show it. If or else not only on the question of limitation, I say read application may not be maintainable because of this is the order of 1980s is challenged in 2015, Milos.
1980s.
But there are 2 read applications, Milos will also kind of find. The connected read application, if you also see, that is WPK number 24957 of 2014 has been filed challenging the order of the revisional code passed under section 15 of the Servant Settlement Act. There this application was disposed of saying that because there is an order under the OA Act, so this petition is not maintainable.
You ready for hearing?
Mr. Mishra is appearing in this case. SP Mishra, Senior Advocate, is appearing in this case. He's on his legs in another court.
All right. As requested on behalf of the party, list the case on 2/9/2024.
Lordship, not in 2.
3.
I'm not available on that week. Yes,
That's how Mr. will argue.
yes, I will assist.
All right.
So next week, another one. Yes.
I'm sorry, extremely sorry, madam.
3/9 is all right. 3/9.
But
He wanted some time. 3/9. Your
next week.
next week ka 3/9 pata? Next week is 3/9.
Next week.
No, 3/9 is no problem.
He want.
Yes.
Okay, 9/9.
9/9 will do. Third month I will be absent after recess. I have some personal work.
No. I'm extremely sorry.
Item 46.
But that interim order is there.
I list along with 24957 of 2014.
That is there, Marcel, along with also
No.
previous order is there.
Fine.
Along with.
Item 46.
What you have received the copy of the counter on Friday, or I will file my rejoinder.
I have served a copy in the petition and serving a copy on the OP number 224 also. I filed the counter on behalf of OP number 1.
Who has filed counter affidavit?
OP number 1 has filed the counter affidavit.
OP number 1 has filed counter affidavit. Online.
On 22nd of August, Lordship. 22nd of August.
File counter affidavit, a copy of which has been served upon learned counsel for the petitioner. The petitioner seeks adjournment to consider the said counter affidavit and file reply if so required. You are?
I am for the opening of 2 to 4.
Copies of the counter has been served on petitioner as well on the OP number 224.
Yes. List this matter on. When?
Next week.
2 weeks. Yes.
Item 47.
My lord, item 47, one passover may continue. My lord, senior counsel, Mr. Mahathi is in court of 15. One
I requested on behalf of the petitioner list this matter tomorrow.
Tomorrow.
Minus.
Item 48.
Tomorrow.
Minus.
Yes. As directed, we are going to take up your case.
Connected matter.
Yeah, my lord. The only issue, my lord, whether 10 black marks is a police personnel, 10 black marks would entail termination from service. That is as per the PMR rules, police manual rules, my lord. But it is also available under the rule that the punishment of black mark can be awarded along with other punishments except removal, dismissal. So here, my lord, the punishment was awarded with stoppage of increment for a particular period. Now the black marks were issued along with that, my lord, along with the punishment for stoppage of increment. Now, if the charge sheeted officer accepts the punishment and on completion of that particular period of punishment of 1 year, whether the black mark can fade away. That is the only issue. Admittedly, when the statutory provision says otherwise, that the black mark is always permanent in nature. With that, your lordship may kindly come to the findings of the honorable single judge. That is at page 10.
See, the purpose of black mark is black mark cannot be given when the punishment is of removal or dismissal.
Yes.
Because that will not serve any purpose.
Yes.
That black mark can be given only in addition to such punishment which does not result into termination of the service.
Yes.
And that is a kind of warning that this is a punishment which has been given to you. All right, this is the purpose. So if the similar misconduct is committed later, maybe of minor nature, again black mark can be given. So now you are earning black mark.
Yes.
So this is the concept.
Yes.
Behind this black mark.
Here the petitioner,
and this is how the black mark is not erased; it remains.
It remains. And here the petitioner.
Yes.
Here the petitioner has earned 10 black marks, which resulted in termination because the rule says on earning 9 black marks, one will be terminated from service. The lordship may kindly have a glance to the findings of the honorable court, my lord. That is at page 10. Before that, I'll take your lordship to the statutory provisions. That would be much.
Is 10 of what?
Of the police manual rules, my lord. Eight 34.
But surprisingly here, the Police Act is still in force.
Yes, madam.
There is a direction by Supreme Court in case of Prakash Singh. Eight
34.
Page 834.
My lord, provision is 834.
Provision is 834.
834. Imposition of black marks.
Yes.
I place it. Black marks may be awarded alone or in addition to other punishments enumerated in Rule 824, except dismissal or removal to all officers of and below the rank of inspector. No more than one black mark shall be awarded for any one offense except with moral turpitude can reasonably be interfered with. Then B, 3 black marks shall ordinarily entail reduction or forfeiture or withholding of an increment, the period of which shall specify the order, and after the period is over, the officer will be restored to his former position. Such reduction or forfeiture or withholding of increment shall not carry any black mark value. It shall be left to the discretion of the officer awarding the 3rd mark to waive the penalty noted in so and so. In exercising this option, he shall consider the offences for which the previous black marks were awarded, the length of time that has elapsed since they were awarded, any good service the defaulter may have to his credit. The next, effect of black mark. A reduction or forfeiture or withholding of increment for specific offense shall carry the following black mark. Then 836, each of 9 black mark, which has happened in this case, my lord. 9 black marks shall entail reduction in rank or compulsory retirement or removal or dismissal whenever any member of the police below the rank of Deputy Superintendent of Police has been awarded 9 black marks. Proceedings shall be drawn up against him with a view to awarding any of the above punishment. Now, what is the general rule, Your Lordship? 837. This has to be interpreted. Black marks shall remain permanently on record and be taken into consideration in dividing the nature and extent of the subsequent punishment. Now, Your Lordship may kindly have a glance to the judgment rendered by the Honorable Singh, which is impugned in the present case matter. That is at page 52 of it. Having heard the learned counsel appearing for the parties and after going through the materials available on record, it is found that in the proceeding initiated against the petitioner by order issued under Annexure A to the counter, he was imposed with 1 black mark in respect of the proceeding 9/10/1996. Similarly, with regard to proceeding intimated on 23/11/1999, the petitioner was awarded with 1 black mark without pecuniary loss. But in the proceeding initiated against the petitioner on 17/8/2000, the petitioner was awarded with 3 black marks with forfeiture of increment for a period of 1 year with cumulative effect. In the proceeding initiated on 24/1/2001, the petitioner was awarded with 2 black marks. And in the proceeding initiated on 4/3/2002, the petitioner was awarded with 1 black mark. Then 6.1. From the orders enclosed by the Annexure A to the counter, it is found that the proceeding initiated on 17/8/2000 by proceeding number 25 of 2000, the petitioner was awarded with 3 black marks with forfeiture of increment for a period of 1 year with cumulative effect. Similarly, in the proceeding initiated on 23/11/1999 by proceeding number 22, the petitioner was awarded with 1 black mark without pecuniary loss. Since the petitioner was removed from his service on his earning 10 black marks, in view of the nature of order passed in proceeding 17/8/2000, when the petitioner was awarded with 3 black marks with forfeiture of increment for a period of 1 year with cumulative effect, in view of the decision of the tribunal so passed in so and so, it cannot be that the petitioner earned 10 black marks and thereby became liable for removal from his service under the PMR 836. in view of the order passed by the tribunal and so confirmed by this court as well as by the Honorable Apex Court, the award of 3 black marks with forfeiture of increment so passed in support of the proceeding 25 of 2000 cannot be taken into account while calculating the total black mark earned by the petitioner. If the said 3 black mark will not be taken into account, then the total black mark earned by the petitioner will come down to 7, and accordingly the petitioner will not be liable for taking recourse to the provision contained in PMR 836. So, my lord,
What was the Supreme Court decision? What was the case in
Supreme Court decision, my lord? The tribunal in a full bench decision observed that this will amount to a double jeopardy if the black marks remains as it is and the punishment which has been awarded, it expires after a particular period. Then it will amount to a double jeopardy. It will remain to continue. So this will cause prejudice. So that order was subsequently challenged before the confirmed by this court and subsequently confirmed by the Supreme Court. But as such, there is no specific judgment with respect to, except confirming the order passed by the tribunal. There is no specific judgment either by this court or by the Honorable Apex Court that the black mark whether will remain permanent in nature in view of the provision 837 or fade away along with the punishment if the punishment is for a particular period. On expiry of that punishment, the black mark will fade away. And in 2 similar cases, my lord, those are pending before the Honorable Apex Court, where the Honorable Apex Court has granted stay. Those 2 cases are also pending. In case of Alek Bag and Devendra Pradhan, that order I'll produce because instantly I don't have it. It is produced. That is the only, the interpretation is 837. The nature of word, your lordship will find, black marks shall remain permanently on record. So in that event, the finding of the...
No, but how the black marks have been calculated by the learned single judge, like what is 13 black marks?
But that he has indicated, to that extent, there was a direction of this Honorable Court also to file an affidavit. We have brought on record how the black marks have been awarded. That is that affidavit.
No, but when the learned single judge records,
yes, ma'am,
that petitioner was removed from service, his earning 10 black marks.
Yes.
In view of nature of orders passed in proceeding related.
He referred to a particular punishment, particular departmental proceeding, where there were 3 black marks were awarded. So the finding of the Honorable Court is that those 3 black marks was awarded along with the stoppage of increment for 1 year. So now if that 1 year expires, so the automatically 3 black marks also expire. So that comes down to 7 black marks, not 9 black marks, which would entail termination of the or removal of the petitioner.
What is the meaning of this page 53? Since petitioner was removed from his service.
In view, removed from his service on earning 10 black marks. In view of the nature of the order passed in the proceeding 17/8/2000, wherein the petitioner was awarded 3 black marks with forfeiture of increment for a period of 1 year with cumulative effect, then the Honorable Court refers to the decision of the tribunal. It cannot be held that the petitioner has earned 10 black marks, thereby became liable for removal from his service under PMR 836. Then in the next paragraph, in view of the order passed by the tribunal, so confirmed by this court as well as
This
by the,
tribunal order was passed in whose case?
in a different case, my lord.
In a different proceeding.
Yes, in a different proceeding.
That's all.
That is the sole issue, my lord.
From this side.
And this police manual has been derived from the Police Act of 1861, my lord. That is from the colonial period. So as per the police manual, so one chapter has been included, that is chapter 15, where punishment has been prescribed in disciplinary proceedings. So black mark is a major penalty here, as per Rule 824 of the police manual. And that is the bone of contention here in my case. My lord, in my career, in 7 proceedings, 10 black marks have been awarded. As per the rule 836, when there is 9 black marks in any career, in my career, so that rule is attracted and major penalty can be imposed. But my point is, the black marks can be calculated wrongly by the authorities in my case. So in one proceeding, there is a black mark, 3 black marks have been awarded for withholding of increment. So as per my contention, as per Rule 834 Clause B, so 3 black marks cannot remain throughout my career, all the period. After the particular period, that increment was withheld for 1 year. So after 1 year, that 3 black marks cannot remain. So it will automatically waive from my service record. That is why the black marks in total.
No, what is the effect of this?
My lord, kindly come to 834 Clause B.
What is the effect of Rule 837?
35, my lord.
837.
837. My lord, the rules here cannot be read segregate manner in segregate. It has to be read coherently. Rule 837 cannot be applicable in my case. When there is punishment, there is a specific provision in case of increment. When there is a punishment of reduction, withholding, so that is related to increment, there is a particular provision, my lord. That is Rule 835. So the punishment related, increment related punishment has a black mark. In my case, increment has been withheld for 1 year. So for that, there is a black mark. So there is an equivalent punishment. There is increment, there is any punishment regarding increment. That means there will be one equivalent black mark for 1 year.
Not so. Please come to 834.
Yes, my lord.
Black marks awarded alone.
Alone
or in addition to other punishments.
Punishments enumerated in Rule 824, except dismissal or removal to all officers of and below the rank of inspector.
So this black mark can be in addition to any of the punishments enumerated in Rule 824.
But not in case of increment, my lord.
No, therefore, even in case of warning, even in case of censure.
No, that is why, my lord, is a special rule for increment. Right? My lord, can't see
Just
there
a
is
minute.
equivalent punishment of black mark given a reduction up to 6 months,
Where are reading?
Sir, Rule 835, my lord.
835, yes.
Say a reduction or forfeiture or withholding of increment for specific offense shall carry the following black mark value, my lord. So a reduction, withholding or forfeiture up to 6 months, it will attract one bar.
That cannot be the interpretation. See, if these are imposed, reduction up to 6 months, 12 months, 12 months. So even if these punishments are there and the punishment of black mark is not there, that will be termed as black mark. So if you are punished thrice for a reduction up to 12 months, then you earn 9 black marks despite the fact that no black mark has been awarded. Are we clear? So even punishment of black mark is awarded to you, in case you are awarded this punishment, that this shall be equivalent to 9. If 3 first thing reduction up to 6 months is given, that amounts to 3 black marks, or once 1 black mark. So if you are, even if no additional black mark is given to you in addition to a punishment, and if you are punished 10 times for this reduction up to 6 months, you earn 10 black marks.
I earn 10 marks as per their calculation.
No,
my lord. My lord, kindly see clause B, my lord. Rule 834, clause B.
Yes.
3 black marks shall ordinarily entail reduction or forfeiture or withholding of an increment.
Yes.
The period of which shall be specified in the order, and after the period is over, the officer will be restored to his former position.
Yes.
Such reduction or forfeiture or withholding of increment shall not carry any black mark value. My lord, in one proceeding, that is proceeding number 49 of 2000, there is a order that award of 3 black marks with forfeiture of increment for a period of 1 year with cumulative effect. So after 1 year, this 3 black marks cannot remain, my lord.
No. See, it's so clear. You have read B? You have read B?
Yes.
What is the effect of black mark? So if you earn 3 black marks, then you can be given this punishment, B. All right. Now come to C.
No, B, my lord, clause B is very much clear.
What?
If any punishment is given relating to increment, like reduction, forfeiture, or withholding, ordinarily 3 black marks can be awarded.
No.
And there must be one particular period for 1 year or 2 years.
No.
So
if
that
3 black marks, if 3 black marks are awarded, then that will entail reduction or forfeiture or withholding of an increment. 3 black.
3 marks shall ordinarily entail means it will say 3 marks. 3 black marks will ordinarily given when there is increment, withholding of increment or reduction of increment.
Such deductions, such black mark will be there. And the black mark will entail this punishment. 3 black mark will entail this punishment. Such reduction or forfeiture returns are not carry any black mark value. It will not become 4. No. See, there is the logic very scientifically prepared. So what see, there are the 1 black mark, there are 1 black mark, 1 black mark.
We all have the mark that we use for withholding. Yes.
No, just a minute.
Another black mark.
Withholding a reduction or forfeiture or withholding of increment and carry the following black mark value. So in addition to this, in black mark, this punishment is given. Please not add something to it.
Okay. So this would have been that if this is done, this amounts to 1 black mark.
But this will not be counted.
This is different.
Because
But
the
this is
punishment,
actually
the punishment is based on punishment will be based on black mark.
Then we come on to this, but it will not be taken as a black mark under this.
All right, and it is clear from C. It is punishment is compulsory to be imposed after 3 black marks. It will be up to administration. But if black mark once given, that remains. That is why it is provision. Yes.
My lord, when 3 black marks are awarded,
Yes.
my lord, here 3 black marks are awarded for withholding the increment for 1 year. So when 3 black marks is awarded for withholding or reduction or forfeiture.
Please appreciate this. Please come to Rule 834B.
Yes, I am just analyzing
It
that.
says 3 black marks.
Yes.
Please read it slowly. 3 black marks shall ordinarily entail reduction. Ordinarily, not compulsorily. Shall entail reduction or forfeiture or withholding of an increment.
My lord.
Period of which shall be specified in the order. All right. So 3 black marks and that. After the period is over, the officer will be restored to his former position. But 3 black marks will be there. They will be there.
No, how? No, the rule says.
It says, Mr. Counsel, please appreciate this, that it says
such reduction or forfeiture or withholding of increment shall not carry any black mark value.
Mark, this you will have to read with 835.
Yes.
Black mark value is mentioned in 835.
Yes, my lord.
So suppose you have 3 black marks and on that ground you are imposed punishment of a reduction up to 6 months. Then there is a black mark value 835 1. So if that punishment is given under 834B, then it will not be considered that there are four black marks, 3 black marks and 1 plus for the punishment.
No, my lord, it is not construed in that manner, my lord. My lord.
Even if you did not have a black punishment which is there in 835 could have been imposed on you. All right. Look at 835.
My lord, that
no,
is
just listen. That punishment which is there in 835, that mentions some punishments and says what is the black mark value. So if that punishment is imposed, that means you have got, let's say, 3 black marks or 1 black mark. But where you already have, while you are counting 1, 2, 3 black marks, that will amount to this, but it will not amount to an extra black mark under 835. Doesn't make sense.
Clear. 835, my lord, 835 says about the equivalency.
No equivalency, Mr. Counsel. Suppose a punishment is imposed on you without any black mark of...
Sir, my lord,
just a minute.
My lord, I'm sorry.
A punishment is awarded on you of a reduction of anything up to 12 months. No black mark. All right. Do you understand the meaning of that? That amounts to, that has the value of 3 black marks. So even if no punishment of 3 black marks is given on and is imposed on you, you have earned 3 black marks because of this punishment. This is mark value. This is black mark value.
My lord, that is why I am saying 835 is a specific provision relating to increment. So any punishment relating to increment like reduction, forfeiture or withholding will be guided as per this principle.
Yes.
As per Rule 830.
Yeah, that will be considered as black mark.
My lord.
So if those punishments are imposed on you, that will amount to that number of black marks. All right.
My lord.
But when under 834, you are being imposed.
So both the rules should be read presently.
Yes.
So again, if you come to 834,
not only both, 3 provisions shall have to be read together.
My lord.
834, 835, 836, and 837. All the 4.
My lord.
No, the language is very clear. The language is very. It's like this. It's like this. If you earn 3 black marks, then there is a provision that shall entail forfeiture or reduction or withholding, anything, three things. Ordinarily, not compulsorily. Now, if you are, because of the three black marks, imposed punishment of
One
increment, one increment, then it says that that will not be added to this three black marks because of 834. All right, 835, because of 835, because three you have already earned, and now because of three you are earning this withholding of increment, then it will not amount to 4 or not amount to 5. It will remain 3. And then it gives discretion whether to impose that punishment or not, 830, 834C. So the language is very clear.
My lord, my point is, so when 837 is considered, 837 cannot be applied in this case. It cannot be, it is a general rule. But the specific rule is when any punishment to increment is given, so that will be guided as per two rules, 835 and 834 clause B.
All right, we'll consider.
So punishment will be considered that it is existing in three punishment in the perpetual case, then it will amount to double jeopardy. So that's the thing. If that will remain and again punishment will be given, that will violate Article 20, my lord.
How is it added? Ultimately, slightly different percent of the difference one year of balance some proceeding.
Yes.
My lord, this issue has been decided by the larger bench of the tribunal, and that has been upheld by this honorable High Court also.
Where is that decision?
Let us see the order of this court.
versus-
Let us see the decision of this court. Where is the decision of this court?
Some
This.
No, not the order which you are challenging. Is there any decision discussing the effect of discussing the black marks chapter of police manual? Is there any decision?
this that has been passed by the larger bench of the tribunal in
Forget tribunal.
and that has been upheld by this.
Where is that order whereby the tribunal judgment has been upheld?
It will place my lord.
Yes, so. Are you very good? Great. Relative to this, not exactly the point. That these black marks add up and that you don't miss. Not in the point. No. Rejection of land that will happen. That's of discussion that is there.
My lord, I have another judgment also.
Mr. You are relying on the tribunal judgment. Where is the decision of this court? See, if there is decision of this court of the coordinate bench, that will bind us. And if we differ, then we will have to refer it to a larger bench.
Kindly to it, my lord.
This is a tribunal.
This is pending in the Supreme Court. The electric decision is pending in the Supreme Court.
Another judgment case is there, Sankarshan Dalai case is there.
Sankarshan Dalai.
That Mr. Das was saying case of Alekbag is pending in the
Sankarshan Dalai, another case is there.
Case that has been dismissed before the Honorable Appellate Court only on the ground of limitation.
No, but the Alekbag is pending.
Alekbag pending.
That Sankarshan Dalai case.
Devraj Pradhan. Two cases are pending.
SLP 7257 of 2024.
Yes. So we need to interpret the provisions under 834 to 837. And we do not find any ambiguity in the language.
Keep it next week. I will submit.
What next week? You were in the morning. You were making a mention for hearing.
About.
Where is that decision?
That is WPC 13624 of 2014. 13624 of 2014 decided on 1/3/2017. Sankarshan Dalai. That is the writ petition and the SLP.
No. What is the decision?
Judgment of the tribunal has been upheld by this Honorable.
Only confirmed.
Mr. Counsel, dismissing a writ petition and upholding these are two different things. We don't know where is the order? You are relying on that order. You don't have the order.
I'll submit.
I'll produce the order if your lordship keep it to
Let us
tomorrow.
WPC 13624 of 2014.
Dated 1/3/2017. Order dated 1/3/2017. Sankarshan Dalai versus Director General of Police.
Bring that order.
Lordship will keep it to tomorrow. I'll produce them.
Does this matter tomorrow?
My lord, beg pardon, my lord.
Counsel for
My lord, next week I will be absent. I'll be absent.
Tomorrow. Wow.
No, I will be absent.
Don't be here. We want to see the order. So as to enable and counsel for the appellate to produce before us the order said to have been passed by Division Bench in double number 13624 of 2014. You have repeated this submission 10 times that the order of the tribunal, decision of the tribunal has been upheld by this court, but you have not produced the order.
I'll produce my.
Then why were you insisting in your case is not being taken up? Your matter is item number 48. So why? If you are not prepared, then you should not have mentioned.
Item 49.
These are a batch of writ appeals against the judgment of the Honorable Single Judge, where your lordships have entertained all these appeals. The Honorable Single Judge at the operative portion at page 109 has directed the writ petitioners to be paid rupees 5 lakhs, and persons who have been selected, their jobs have also been terminated.
Yes, yes.
It's that
Remember.
So if my lords would see, our points are this, my lords. If the petitioners get 5 lakhs and nobody gets the job, so it's basically it's a zero thing. And the operative portion is also contrary to earlier directions of the tribunal and this honorable court in the division bench. And the basic ground that the deputy director issued the advertisement, that would not prejudice the writ petitioners, because they have, in fact, we have got that data which my lord wanted.
Because it's a question of competence.
My lord, there we would argue that it was there was the director had issued the deputy director that you kindly issue the advertisement. That's also a part of your lordship's records. So the petitioners would not be prejudiced. They are after all responding to an advertisement.
There are two issues the single judge has dealt with and disposed of the writ application. One of the issue is that in the earlier judgment there was a direction that corrigendum is required to be issued in terms of the rules. Rule 4 is the important, where preference is to be given to the person those who are agriculture, vocational agricultures. In fact, while issuing this next advertisement, that Rule 4 language has been incorporated. Whatever deficiency was there, that deficiency has been removed. But the Honorable Single Judge has simply said, because both are directed to issue a corrigendum and no corrigendum has been issued, therefore the advertisement is illegal. The advertisement is illegal, any appointment made pursuant to that advertisement made. And this next question is regarding the competence, as your lordship rightly pointed out. The question is deputy director. Deputy director has issued the advertisement. In fact, if your lordship will see the advertisement in the first line, pursuant to the order passed by this honorable court and the decision taken by the government, deputy director issued the advertisement. So practically, and we have been working, we have been selected, we are the candidate who have not only been selected, got the appointment, and we continuing from right from 2000, we have completed about 10 years of service. And now, as
regularized also.
In the meantime, their service have been regularized. Now, my non-friend has also filed some appeal that is also.
That is that, it has also come along with this.
So if the lordship will, then we can proceed up.
We get tomorrow.
Tomorrow there are some matters will 6 at 2 o'clock. Can you lordship fix any date next week at 2 o'clock?
Yes,
any date.
Why are you so happy?
7 because tomorrow that will be difficult.
Why, is there any order in your favor? No. As jointly requested, list these matters on.
Next week.
In order to continue. The lordship fixed any date or
1 week means 1 week date.
Monday basically.
Entry what is that?
9 to 10. Third is on
Monday.
We are actually continuing in terms of your lordship's interim order, otherwise we'll be out of the job.
So Monday is 2nd.
Yes.
Item 50.
Item 50, may I please, Lordship? Lordship, I apologize for non-appearance from the last occasion, Lordship. Lordship, the counter affiliation filed, but the copy has not served, Lordship.
Counter affidavit has been filed.
Yes, Your Lordship, we filed a counter affidavit.
But
Let's
it
have
does
a
not have a
copy.
copy.
Let's have a copy, Your Lordship.
A copy of the counter affidavit said to have been filed on behalf of the estate be served upon land counsel for the petitioner by tomorrow. By tomorrow.
By tomorrow.
By tomorrow. Place this matter on 3 weeks so as to enable land counsel for the petitioner to consider the said counter affidavit and file a reply if so required.
Item 51.
Just would I say objection on me? Can it be next week?
Objection? Again?
Objection to the WA. Objection to the redapping. And Lord and Friend has served an objection to the redapping.
How can you file objection to the redapping?
I don't know what. Yes.
How can
Hello, sir.
Limited,
Now, what is the question?
limited question is whether he is entitled for TBA from 1988 or from 1991. Initially, he was appointed under
entitled for what?
TBA.
TBA and or a
TBA. TBA is what? Time on?
Time bound advancement.
Scale after continuous service of 15 years.
Initially, he was appointed in industry department in ITI as a supervisor in 1988. Then, after a due selection in 1991, he came to the energy department. He claims that as per the letter of the government and as per the letter of the chief engineer, he is entitled from 88. But the rule says from the completion of 15 years. That is the short point, my lord.
Yes.
My lord. My lord, in the read petition, kindly see Annexure 1, my lord.
One line more. And though there is no prayer in the writ appeal for consequential benefits, but in the IA, the Honorable Single has also granted that relief, which is not the prayer in the writ application. That both the orders have challenged. And my submission is as per the rules, he is entitled for TBA from the date of his appointment after completion of 15 years in a post-public cadre. That is the only point. That is why your lordship was for in post of cadre. Here the supervisor cadre in industry department is separate. Here in energy department, he was appointed as a junior engineer, whereas in industry department, he was appointed as a supervisor. He says, in view of the letter of the government, as well, the government letter is for the purpose of pension services regularized from 88, not for the purpose of TBA. It is a separate.
It appears to be correct in submission.
My lord. My lord, kindly see the Annexure 1 is the letter of the Additional Secretary to Government, my lord. My lord, second para, this has been regularized by the office order number so and so of engineer chief. The period of service from 5/7/88 to 18/11/91 render under the industry department will be counted for qualifying service for the purpose of pension, my lord.
Okay.
My lord, thereafter.
You may get pension on that benefit,
My lord,
but not this TBA.
TBA, my lord. TBA is, my lord, the
TBA will be governed by the rules.
After completion of the 15 years continuous service.
In the cadre. If the rule says cadre, you will
My
have
lord,
to do it in that cadre.
My lord, cadre is same, my lord. My lord, the petitioner having the diploma in electrical engineering, my lord.
All right. That is not the
Qualification
cadre.
is same, my lord.
That is not the cadre.
My lord, he was appointed as a ITI supervisor.
All right.
The scale of pay is same, my lord. It's a diploma engineer and the supervisor, same.
All right.
1400 to 2600, my lord. The scale is same and the qualification is same, my lord.
That is not the cadre. So cadre has a cadre is a different meaning in service law. Tomorrow we will pass on this.
Yes.
Tomorrow.
Item 52.
This is a
Please
matter
please give the rules also. Rules you have given.
Yes, my lord.
Yes.
This is a matter regarding leakage of question paper in respect of recruitment for the post of junior engineer civil. That examination was scheduled to be held on 16/7/2023. The previous night, on 15th night, the question paper was leaked, and some of the students of various parts of the state, they assembled at Bhubaneswar, and from Bhubaneswar they went to Digha, that means West Bengal border. And there, with the miscreants, those who have collected the leakage question paper, they met with them.
Then what is
And
the
there is a monetary transaction there, and all other things are there. And at that moment, the police got the news and immediately arrested the accused persons and also to the students, the candidates. The candidates, because the examination was scheduled to be on the very next day morning, the police allowed them to go and appear in the examination, and I submitted a report
you
to
are
the.
for whom?
I am for the Staff Selection Commission.
Yes.
So SP submitted a report that is under Annexure 3
Yes.
to the Staff Selection Commission. That is a report of the SP as page 40.
So which action was under challenge before the?
Now a so-called notice on the basis of that police FIR was lodged. The police investigation is now going on, notice going. And we also issued so-called notice to the accused person, those who are involved in the leakage of question paper and getting access to the question paper. Because as per the rules, the candidates, even before or after, they cannot involve to get the access to the question paper. So therefore, notice was issued to them. That notice is at Annexure 4. That is page 47. For a moment, let's kindly see the notice, the so-cause. That is 47. The notice says that as per the report of the Baleshwar police, it has come to light.
Why did you challenge the order?
I am challenging it because the Honorable Judge has held that the so-called notice has already held that they are not the accused person, the so-called notice, you exonerate them, and if they are selected, you give them appointment. Even pendency of the criminal case will not be a bar to give them appointment.
Where is it?
That is Annexure 8. So our so-called has become redundant. Page 166. That is the order. Annexure 8 that has been impugned here, you must.
Page?
Page 166. It starts from page 166. I'm placing the relevant person, I'm placing the entire facts and page from page 5, paragraph 5. Further, referring to the statement of the petitioners recorded under 161 CRPC, the IO filed an affidavit and stated that a couple of days before the schedule of date of examination, the petitioners received phone call from accused persons to receive question paper by paying a sum of rupees 15 to 80 lakhs. The petitioner, being desperate to qualify for the job, came to Talsari. The Honorable Court said because desperate they came to Talsari.
Who is the pairing?
I'm
Findings of the IO cannot be.
No. Let's just see the next paragraph 6. Not on inquiry, paragraph 6. On inquiry, the IO has come.
The IO will not.
Sir, I'm coming. What is the ultimate finding of the Honorable Single Judge?
Paragraph 9.
Yes. Paragraph 10. Paragraph 7 and 10. Let's just have a glance. The aforesaid affidavit by the IO gives a prima facie inference that the occurrence took place in two parts. First, the question paper were leaked. Secondly, leaked question paper were sold to the
It appears from the order passed that IO, that the entire order is based on the findings of the IO.
So, what is the direction? Ultimate direction is kindly paragraph 10. Just for a moment.
Yes.
In the aforesaid factual backdrop, this court permits the IO to continue with the investigation with a direction to conclude the same as expeditiously as possible by covering all angles species. Further, this court also direct the OSSC, the petitioner, to finalize the proceeding initiated by issuing so-cause notice to the petitioner, to which the petitioner have already filed the reply. In the event it is found that the petitioner in no way involved in the leakage of question paper, then such proceeding be dropped and the result of the examination which was held on 3/9/2023 in respect of the present petitioner be published within 6 weeks from the date of communication of the order. Furthermore, in the event it is found that petitioner have come out successful in the written examination and in the proceeding against them are dropped as directed herein above. The OSCCB proceed in the matter for publication of the final result by taking the necessary and consequential step to conclude the recruitment process in respect of petitioner. Consequently, if it is found that petitioner finally selected, then the pendency of the criminal case shall not stand in the way of the petitioner being considered for appointment to the post of junior engineer. My learned friend says that so-called notice has been issued. Yes, what the Honorable Single Judge said, you proceed in the so-called and consider it. And if you ultimately find that they are not guilty or they are not no way connected with the leakage of the question paper, then you publish the results, nothing else. And so far as the criminal case is also the Honorable Single Judge said, proceed. Let's say again look to paragraph 10. Very in the aforesaid factual backdrop, this court permit the IO to continue with the investigation with the direction to conclude the same as expeditiously as possible by covering all angles of conspiracy. Further, this court also direct the OSSCC to finalize the proceeding initiated by issuing so-called notice to the petitioner, to which the petitioner already filed the reply. In the event it is found that the petitioner in no way can involve in the leakage, and them to take a decision on the so-called.
Question is that whether petitioners are involved with the leakage of question paper, or
You have to take
or they are getting access to the question paper. The Honorable paragraph 7, let's look at paragraph 7, what is the observation of this Honorable Court? It is already observed, they are not involved. We already observed in paragraph 7. I am reading it out. The aforesaid affidavit filed by the IOD gives a prima facie inference that occurrence took place in two parts. Firstly, the question paper were leaked. Secondly, the leaked question paper were sold to the aspirant candidates. The second is important. The petitioners who were the...
We will clarify.
The General Lordship kindly turn to paragraph 8.
We can, if you are aggrieved by this observation, then we can clarify.
Yes, you also clarify. If petitioners are involved in getting access to the question paper,
that we can do.
That we can do this.
My non-friend is trying to say
that may be clarified.
that so far as leakage and access,
yes,
you'll also see the rule. Rule 8.
He is saying you may not be involved in leakage.
Yes.
But you have made use of the question
So,
paper. You've got access.
That is a rule. That is a rule. Rule 18 is the statutory rule, and the so also in consonance to the rules. So now the question is leakage or access. I think that is nothing to be differentiated. And since the Honorable Single Judge said that you can proceed with the so-called already reply has been given by the petitioner, let them proceed at whatever they will.
We are getting access to the question paper. Our notice is they are trying to get the access to the question paper, not the leakage means the outside state person.
Just a minute.
Yes.
Final decision is to be taken by you.
Yes.
Whatever notice has been issued, they'll have the liberty decision in appropriate. So far the access is concerned, suppose you are addressing this court.
No,
suppose you are addressing the court,
yes.
Just a minute, addressing the court,
yes.
And while turning the page, you find that the question which was leaked was there in your brief. So you have access to the leaked question paper.
Yes.
Access by chance, access with intention.
Yes.
These are two, and final decision has to be taken by you. You will be taking
the Honorable Court in paragraph 7.
We will clarify that.
Yes, that will clarify. That is the point. That will clarify.
Only you have to look to page 25. What is the place 25? That is the so-called. Just for a moment. This is the so-called they have issued. We have given the reply. Just page 25. Reference report of the SP Valuation in connection with the so-and-so case. As per the report, the subject is so-called notice. Involving illegal obtaining access to question paper so-and-so. You also look to as per the report of Baleshwar police, it has come to light that you had illegally obtained access to the question paper so-and-so. They refer to the report of the SP, and report of the SP is leakage.
No, report of the SP. Got access to the question paper.
Yes.
I am placing the report. Report says they have got the access.
They have to take a decision on the so-called. We have given the reply.
Yes, that's clarification.
Anyway, and show us the rules.
Yes, rule 18.
Yes. No, the entire rules.
Yes.
Tomorrow, not today.
Tomorrow they have,
I may pardon, my lord, item 54. May prefer to day after tomorrow, my lord, item 54.
All right.
This matter adding part.
Adding part from first. Nothing.
Adding part means what?
No.
That is continuing. Your lordship is continuing.
No, let's keep it.